Yes.
Worship in MFA number 2018 of 2024, madam. Kindly, the matter can be postponed tomorrow, my lord. It is an urgency. Plaintiffs are trying to dispose the defendant peaceful.
WP, you're saying,
My lordship?
you're saying WP
No, my lordship, MFA.
2024
Yes, my lord.
is tomorrow.
Please. My lord, the husband's petition, my lord, challenging expert.
Yes.
My lord, it's husband petition against the export maintenance order tomorrow for the
Which year?
2020.
20? Objections are complied with? If objections
all
are complied,
complied-
office objections are complied with?
Notice also.
Yes.
Even complete. Filed in July.
Office objections are complied with, let all the 2024 MFAs will be posted,
My,
provided there
My lordship,
my lord, end of the list, man.
will come, just wait.
2022, madam.
No, if a date is given, don't post it. So when interim order also, tell them if interim orders are not there, then let it be listed. If interim orders are there, on appellant's request, don't list the matters. Yes,
My lordship, MFA number 2179, my
that's
lordship.
what you give it. Yes.
My lordship, the matter is not listed or since 2022, my lordship.
Yes, Mr. Counsel.
Yes, my lordship, I have to submission to make in MFA number 5506 of 2024, my lordship. This matter was listed on 31st in this case, and that time, my lordship, the matter was held and reserved for orders in this case. My lordship, the appeal has been challenging has been filed challenging the order passed under 39 rule 1 and 2 in this case, wherein, my lordship, the Honorable High Court, Trial Court has given a liberty to the respondent to dispose their property in this case. Now, my lordship, this I am filing in a memo. In this case, my lordship, undertaking that I am not going to alienate the property till disposal of the suit in this case.
Hmm.
Now the matter is for reserved for orders in this case on 5th case.
Hmm.
I am filing
So
in a
you're
memo.
giving so on that it can be disposed of according.
Yes, my lordship. I am ready to give an undertaking that I am not going to alienate the property till disposal.
Yes.
What is that?
For salary attachment of the respondent, one third for the.
No,
petitioner.
before mentioning about what is the case, first tell the court about which writ petition, which year. Then the court will understand.
WPA,
WP of which year?
24.
When was it filed?
Filed on July 20th, madam.
It was never listed before the court.
Yeah, it's listed and it's a order for 3,000 rupees maintenance amount. If the petitioner is having 2 daughters there. they
Then what happened?
They're seeking for the salary attachments of the respondent.
How many orders you want in your matter, one after the other? There are so many other matters which are important or pending. Yes,
Matter.
yes.
MFA 2081 and 84 are connected matters. Potentially, after passing the impugned order, the respondents have put up compound wall by including the sheet roof.
Which year is that?
2024.
When it has come up before this court earlier?
In the April, it has come up.
What has happened in
So
April?
after passing the impugned order in the trial court, the respondents have put up compound wall by including the sheet roofing shed existing in the suitable property. Now the appellant is unable to move the existing shed in the suitable property because.
You know, what I'm asking you is, it has come up earlier before the court.
Yes.
This MFA.
Yes.
What was the order on that day?
Kindly see the commissioner has been appointed by the Honorable Court. The commissioner has filed the report saying that the.
Was this matter on Wednesday? Yes.
The fresh matter, my lord. MFA.
I don't know.
Matter of his objections are complied with, it will come.
May have it tomorrow because it's.
If it is complied with, it will come.
Good for
Yes,
specific for her.
yes.
My lords is for kindly
Please come in line. Yes.
the MFA, my lords, of 2024 for withdrawal, my lord, kindly post end of the list. The court said that it is not maintainable under MFA.
Yes, call for it after 2:30.
My lords, WP 12734, it is,
It's a memo.
my lords, it is already moved last week, my lords.
Give the
To be
best memo. You
spoken.
will not give the memo to the court officer?
My lords, today it was a date given matter, my lords, and it is not listed, my lords. It's a date given matter to be spoken to.
Give to the court officer, write on a paper and
Please,
give
my
her.
lords, I will.
Yes.
family court filed by the application.
Could
party
let it come
application.
tomorrow. Why has it not come for being spoken to? Why are they not posting? Let it be listed. Yes,
Like, family court filed by the wife for 45 application, my lord, challenge before the court, my lord. DNA
which year is the petition?
2024, my lord.
When it has
I-
come up before the court earlier?
No, fresh matter, my lord.
Fresh matter, office object,
one-
all the fresh
one-
matters give it to the
file-
court officer.
one-
If they have not yet listed till now, then if the office objections are complied, it will
Officer
come.
didn't complain, my lord.
Then it will come.
Right.
Yes,
Today is posted
MFA
in the
may
trial
not-
court, that's the reason. Today is posted, the trial court is matter, my lord.
we can't help it. Yes.
MFA 2015, my lord. The arbitration were appointed, my lord, by the Sanambal court, my lord. Thereafter, appellant has challenged the arbitrator appointed by the arbiter, my lord. Trial court had dismissed the OS filed by the appellant, my lord. Appellant has filed the MFA before the Sanambal court, my lord. The Sanambal court has stayed, my lord. I moved for final hearing, my lord. 2015 matter, my lord.
Take that slave, pose that matter on 30th of September. Yes.
My lord, is it 2020 matter? I am for the respondent. I have filed the written objections to it. So since then, the matter has been not posted before this honorable court.
Pose
Kindly.
matter on 23rd of September. Yes. Call the list.
22 matter. Deputy Registrar passed order imposing duty and penalty. Held it. Challenge that order before the
Pose the matter on October 14th.
One mentioning, my lord.
14th.
One mentioning, my lord. Serial number 12, my lord.
No, they'll call. Yes.
And this one, page 1, serial number 2 to 4, page 2,
My lord,
5 to 9.
serial number 4, my lord. For respondent, my lord, we need to file a wakalat. Now we have received the hand summons.
Inform the other side.
No, not.
My lord,
Then
my
wait
lord, I
till
appear
they
for the
come.
petitioner in this case, my lords.
Yes.
Yeah, I hasn't served the copy to me, the objection, my lord. We have
My
complained.
lord, still we have not filed the wakalat at all. The client is in
Request of the
Canada. my
Counsel for the respondent. Pose this matter on 25th of September. Yes,
Much
next.
obliged.
Page number 2, serial number 5 to 9, page 3, 10 to 14.
Serial number 12, my lordship.
Hmm.
I appear for respondent. My lordship, arguing counsel is not well. I request for 1 week time.
Inform the other side.
I have informed, my lordship.
Then at the request of the counsel for the respondent, pose this matter next week. It is submitted that they've already informed the appellant.
Date
Yes,
may be fixed.
Counsel for the appellant. Next week,
Page number 4, serial number 15 to 20.
date is on 18th.
Grateful, my lordship.
Yes.
15 to 20.
Any interim order is in this case? If
Any
look at it, if interim order is there, extended.
Right.
Till the next date of hearing. Yes.
Page number 4, serial number 15 to 20, page 5, 21 to 25.
Please, my lords.
The honorable court had asked us to give the payments, memo of payments, because we had told the petitioner is suffering from few diseases. The court had asked to produce few payments, the receipts and the documents. We, if permitted, will be filing it in the counter. So we've informed the other side, we'll be serving the copies to them.
At the request of counsel for the petitioner, pose this matter on 30th of September. Yes, next.
Grateful, my lords.
Serial number
Serial number 22, my lord. Serial number 22. I'm for the respondent.
And for the petitioner, we are ready for the parties are ready to settle the matter, your lordship.
Yes, kindly refer to mediation.
It, 22, it is submitted that there is a likelihood of settlement. Both the parties shall appear before the, where are they? Which place?
Mysore, your lordship.
Before the mediation center at Mysore. On which date?
Next week, any date.
Mysore. Please, your lordship.
Shall appear before the mediation center at Mysore on 11th,
Please, my
Your
lord.
lordship.
no, on 18th, on Wednesday, 18th. And the registrar at 3 o'clock, the registrar judicial shall communicate the same and the relevant record shall be sent. Yes.
Page number 6, serial number 26 to 28, page 7, 29 to 34, page 8, 35 to 37, page 9, 38 to 40, page 10, serial number 41, 42. Which one?
Serial number 12, no interim orders.
But they will see. If it
Yes,
is there,
great.
then they will explain.
Grateful.
Serial number 1 for being spoken to.
In this case, I appeal for the petitioner. The only MC number, my lord, is it is instead of 6153, it is typed as 2599 at page number 3.
Yes.
That number 2, paragraph from page number 2, paragraph number 3. The second line
Two, paragraph
Paragraph
number 3.
number-
It is mentioned as?
that I have mentioned in the memo.
Hmm.
That line number 2, MC number 2599 of 2022. Instead of it is to be typed as 61, MC number 6153 of 2023. Because that 2599 was also filed for restriction of conjugal rights by the petitioner against the respondent.
No.
Huh.
No, what is a typographical mistake? The MC seeking restitution conjugal rights?
It is legal rights, restitution of conjugal legal rights, and the husband had filed MC number 2599 of 22 seeking divorce. The 20, instead of 2599, my lord, it is to be inserted as 6153 of 2023.
6153 of
Of 2023, because that provision petition was also restituted.
That's the only thing?
That's the only thing.
The petition, the matter is placed before this court and the caption for being spoken to. It is submitted that in the order at paragraph 3 of the order, the MC number, the MC that's filed by the husband seeking divorce is 6153 of 2023.
By 3.
6153 of 2023. Instead of that is mentioned as MC number 2599 of 2022. The same shall be corrected at para number 3 and the corrected copy shall be uploaded.
For the respondent.
Oh, bless.
Serial number 2. Sudhakar
Yes.
PD.
For the petitioner, madam. Appellant.
And for the
I have
response
filed
number
an-
427, my lord, I have filed an wakalat in this matter.
I'm challenging the ex parte order.
Ready for arguments?
Sorry, my lord?
You're
They are
ready?
the
But no.
sellers of the vendors of the appellant here. The suit is filed by the respondents number 1 to 3 herein. The plain copy is at page number 22. Page number,
No, where, I think no wakalat is fine for the respondents.
the respondents.
Respondent number 427, I have.
Then what about notice to the other respondents?
No, my lord, it has come for the admission
Coming up for the first time?
first time.
No, but in the meantime, they say that they've already, no notice is ordered till now.
No,
We are
no,
also
it's not.
sailing with the appellants here in my lords. Because even we are aggrieved by the order, we are the purchasers in 2017. Pursuant to which we have also alienated the property and made plots.
What is the suit for?
Suit for declaration, my lord.
You're the,
I'm the defendant's number 629.
yes.
The case of the plaintiff, my lord, the plaintiffs and defendant number 5 executed a jointly sale deed in favor of the defendants number 1 to 4. The plain copy is at page number 22, ma'am.
You appear for defendant number?
6 to 9.
I appear for defendant number 1 to 4, my lords.
Yes.
Entire case of the plaintiff, my lord, along with the plaintiff, they have produced. the plaintiff. Most important document is the sale deed executed by the plaintiff and defendant 5. Which is at Madam. along with
Pose this matter before the other bench. After obtaining necessary orders from the Honorable Chief Justice.
my lord, after taking the interim order, the petitioners from the Andhra Pradesh, my lord, they are not localites here. After taking the interim order, they have demolished the compound walls of the neighboring properties.
Expressing the urgency, they pose this matter tomorrow. From before any other bench, because they express, yes.
Serial number 3.
Yes, we are petitioner, my lord. Yes, yes, we are for the petitioners.
Yes,
My lords, we have filed a memo for retirement in the,
you filed a memo,
for retirement in the,
where is that?
my lords, it's filed on 29th August, my lords.
It's served on them.
My lords, it's not served on them. I haven't been able to contact the advocate, my
Huh?
lords. For the advocate, my lords.
To whomsoever you have sent this, there's no objection,
Please, my lords.
retirement, it's served on them?
Yes, my lords.
And is it
Your
served?
lordship may kindly see,
Well,
page
this is
number-
another-
the last page, my
Very
lords, where I have
simple,
enclosed a postal acknowledgement, my lords.
A memo of retirement is filed with the respondent. It is stated that they have written a letter to the respondent 12/7/2024 by way of RPAD and requested her to come down to the office to file her assets and liabilities. The said letter has been received by the addressee of the respondent. The letter dated 12/7/2024, they've informed the respondent that if she doesn't turn up, they're going to retire from the case. The respondent, in spite of receipt of the letter, has not approached the undersigned, has not approached the advocate to file assets and liabilities, and they have filed this memo of retirement. And they have also filed the letter addressed and the acknowledgement. Concerning the same, respondent is permitted to retire when the name of the party pose this matter on 18th of September.
My lord, that MC is listed for judgment on 20th September. Any date after 20th September, that MC
So you want
61.
it before or after?
No, no, after.
Pose
But
this
if-
matter on 30th September.
Oblige, my lord.
Serial number 4 urgent. Serial number 5. Venkat Reddy CM.
Petitioner, madam.
Yes,
His husband petition, madam. The respondent number 1 and 2 filed in maintenance petition.
how much is granted?
My lord, before that facts, she filed a petition in the year 2013. Wife and daughter. She got the interim order at 2000 each. The both of them filed a revision petition before appellate court. Before appellate court, the matter has been settled. She agreed to stay with this petitioner. In the 2020, she left the matrimonial house with some family arrangements. Now she has filed in claiming arrears in the 13 to 17. Instead of filing the maintenance, she did not seek the maintenance. She is asking arrears of the maintenance. Instead of, she received some lump sum amount within the family arrangements.
Where is that?
That is not, there is no order.
Then-
But she is not claiming maintenance now. She is claiming only arrears, my lord. She got the attachment order now in the 2013 to 17,
No,
not to present
Even
years.
before the order passed in RPFC or in any other,
CRP. madam.
in CRP, then if you're not paying, she's entitled.
She's got the one-time settlement, madam.
Where is that order?
There's the family arrangements, madam. There is no separate order. Now
How the court can understand all this?
she's not claiming maintenance now. Up to she is asking arrears only 13 to 17, not present year, my lord.
Can't she ask?
If she had not received any amount she would have filed a separate petition for maintenance till date.
How the court had dealt with it.
She has not filed separate petition for maintenance
Please
till
come
date.
to the order. Please come to the order.
Now I'm challenging the annexure F, my lord, page 30,
Page?
43, my lord.
Yes. What is the order at page 43? Petition and counsel present, respondent absent, no representation. Arrest warrant against respondent returned as door locked. Absent, FLW issued against respondent, returned
First,
unexecuted. Respondent is not owning any more considering the absence of respondent since 2017. Issue attachment warrant of mobile by break open the lock.
If she had not received any amount from the present petitioner.
Don't
she
go
would-
to all that. When you have received a notice from the court, why have you not appeared?
He did not appear
You
before
have
the
not
trial.
appeared, and why should this court interfere with this order? Now, all these things will arise once you appear before the court and submit to the court that
Yes,
these
ma'am.
are all the facts. Otherwise, how would the court know?
One submission, madam. If she had not received any lump sum amount from the petitioner, she would have filed and maintenance.
Tell,
till-
court has to assume and presume things. Court will not assume things.
She would have
Please
claimed the
don't tell that
maintenance petition.
argument, Mr. Counsel, again and again. You have to be present before the court and tell the court. Why were you not present?
Only arrears 2 lakhs is there, madam. I'm ready to deposit 1 lakh, my lord.
We will not, why should we interfere first? That's a question.
Instead of she has taken.
Don't even
lump sum
go
of-
before the court. You don't appear from 2017. Court waits for you till 2024.
She has taken lump sum amount,
Please
that's
don't
why
tell
it did
that.
not
It is
appear
not
before
about
the
lump
trial
sum
court.
amount. When you have received the notice from the court, it is your duty to appear before the
Yes,
court.
my lord, agree,
That
my
is the first and foremost submission you have to make. Why?
Yes, my lord, it did not appear before the trial court. ma'am.
Then what is wrong with the order? Next question is that.
Yes. ma'am. I'm ready to deposit 1 lakh, my lord. Only 2 lakhs is their arrears. Let them appear before this court, my lord.
Why this should go on from there to here, here to there? What is this shuttling?
Because a restaurant has been issued and.
Will be issued,
Yes,
put
ma'am.
that the court has issued this order. When you have no respect to the order of the court. Now you will not go before the trial court, you will come before the high court, both are courts.
Yes, my lord.
When you can go before, when you can't appear before that court, why should you come before this court?
Unless the entire
What
amount
happens
deposit.
is if these kind of petitions are entertained, then everybody, this would be the practice. That okay, that let me not appear before the trial court, I'll go to the high court and obtain orders.
What assuming petition, my lord, the entire amount.
Now, what is wrong with the order now? While exercising the jurisdiction under 227, what is that the court has to do? What is wrong with the order? Tell the court.
Nothing.
Nothing is wrong.
Nothing.
Uh,
Because why is he did not appear before court, my lord? She has taken lump sum amount from the petitioner. That's why matter has been settled.
Then let-
The assuming that he did not appear
No,
before the court.
because she has already taken lump sum amount, you do not want to appear before the court. Now also don't appear.
Now warrant has been
They will
issued.
do, that will continue. Unnecessarily, you made the court to do the exercise from when? How many times the matter has appeared before the court? How much of judicial time you have wasted?
It did not appear.
Pay the amount, pay the entire amount to her, then automatically the court will do it.
50% I will deposit. 50%.
Go before the same court.
They will not entire amount unless the deposit entire amount, they won't recall the warrant amount. 2,10,000 is there, madam, arrears. 50% I will deposit in 2 weeks.
By tomorrow you deposit.
More not ma'am, possible.
Then we will
At
not
least
interfere.
1 week.
First of all, it's not a case for,
1 week.
not a case for interference at all. Why should we? Yes.
Hello, one week I will deposit, madam.
It is submitted, the land counsel for the petition submits that. There was a settlement between the parties and he has paid a lump sum amount. Now a petition is filed now a petition is filed by the wife seeking arrears from 13 to 17. And the court has issued FLW. It is submitted that after taking the entire amount, now she cannot file this petition. Next, this court has perused the order, wherein the court observes that in spite of repeated notice, the petitioner has not appeared before the court. As such, the court had issued the warrants. This is not a case where the court can interfere when the petitioner has no respect to the orders of the court, respect towards the court. When notices are served, you ought to appear before the court. However, considering the fact that he is ready to deposit the amount, there shall be stay of all further proceedings pursuant to the order dated so and so.
There are
The
two
condition
petitions are
that.
there. Two separate petitions are there. Next, F and G. She filed in different years, claiming different years. 15 to 17 one
Both,
petition,
what is the amount?
both 2,10,000.
So and so, write that numbers. There shall be stay of all further proceedings in so and so, on the condition that the petitioner shall deposit an amount of rupees 1 lakh by 1 lakh by 9th of September, or else the order granted by this court shall stand vacated without further reference to the court. Petitioner is permitted to take court notice on the counsel appearing with the respondent before the court, before the trial, before the court, before the executing court, and shall file a memo by 10th of September. Yes, even if the memo is not filed, even on that ground also, the stay granted by this court still stand vacated. Yes.
Till number 6, B.V. Badrinath, for petitioner.
Petitioner, he has filed a diverse petition in the trial court. He has sought permission for video conference. That application has been dismissed now. On the ground that the delay on my part in appearing before the court and conducting the proceedings. That is the main ground on which the trial court.
Why
dismissed.
video conference?
Video conference is a judicial officer. 2 or 3 court, a concurrent jurisdiction has been given. 2 or 3, he is in charge of 2 or 3 courts. Every time he can't appear before court because he has to travel from hospital and to Chikbalapur here, come to Bangalore here and travel to Chikbalapur. That is the reason, that is the reason sought. And on a health issue also, he remained absent for 1 or 2 hearings. That the court did not consider it. Trial court rejected the application on the ground that the fair trial cannot take place through video conference. That is the ground on which an application.
This court is also in several cases has dismissed those applications where this in a family matters, this cross-examination cannot go on virtually.
May I request your lordship to kindly turn to page 217. This court, this court observed. Decision, the reported decision. Reported decision. Page 217, para 15. May I read? Para 15.
Now, there are so many difficulties in that.
May I read? Madam?
Yes.
Secondly, the question that needs to be examined by this court is as to whether defendant number 1 can insist for trial through video conferencing as a matter of right. Video conferencing does have a place in the legal system. The challenge is not to exclude it, but to use it with responsibility. Post-pandemic situation, the courts are compelled to adopt some alternatives. Video conferencing is now most sought after alternative. Recording of evidence by video conferencing can be used only in those cases where there is no compulsion for the parties to appear before the court or where the parties are unable to appear before the court. This is the ground I was made out there. The very object of having recourse to video conferencing is to eradicate huge time consumption. In cases where witness cannot appear before court without any inordinate delay, expense or inconvenience, the court may consider recording evidence by way of video conferencing. On reading rules 6.2 of the rules, what emerges in the consent of the other party is not completely ruled out. In some cases, the court can exercise the jurisdiction, can exercise its discretion.
No. How a party can be cross-examined through video conferencing?
Like if the
The Honorable Supreme Court says, even in, I can understand and export evidence between a parties in a matrimonial proceedings. Now, sometimes when you file an application for appointment of a commissioner to record the evidence, there are several judgments where the Honorable Apex Court said that that it cannot be, because the court has to, the demeanor of the witness and all other aspects are very much relevant while doing the cross-examination. That is, in all these kind of things, that would be the crucial aspect. And if the parties are before the court, it would be convenient for the court, that too in a matrimonial matter, cross-examination. Because we have rules, we do have rules.
High
but
Court
that
has framed the
doesn't-
rules.
Court has made, High Court had made the rules and there are difficulties in that. Those rules are made during the pandemic. No, those rules needs to be amended. There are some problems in that. So just because the rules are there, we cannot permit as far as expert witnesses and all concerned, it can be done, but not for the parties.
What
this
I
point
request,
of
no,
time.
what I request, my lord, that the trial court permit me to appear through video conferencing where it is required, absolutely required by the trial court to
Now it is what
find
the
out
stage?
the demeanor of the
Please
witness, I will appear.
Come to the order. What is the stage? And where is your IA? Where is the
My IA, my lord,
page number?
page number, point out. The problem is every day the matter is within a matter of span of 1 week that is matter is being posted.
Really, your presence is not required. Only for the cross-examination, you need to be there.
No, the trial court observed it, my lord.
Please,
Trial court observed,
please come to that.
page number 122. my lord.
The matter is reserved. Softly with regard to the video conference. Judgments in this. The judgments in
No, 122, no,
that you do.
application. Application.
Yes.
197, page 97, my lord. My IA, my application, third application. Dated 17/2/2025. I'm sorry. my lord. 130. That is on page 110. my lord. Kindly turn to page 110. Application filed.
For appearing
For
before the
tendering-
mediator, you want to, it has to be through video conference.
My request is only one. Because huge,
What is the purpose of mediation?
no, purpose of mediation is to find out the parties' minds, whether they able to appear, find out some resolution among them to dispose of the matter, that's all. The mediation. takes-
This mediation is going on a day-to-day basis
No,
for
no.
days together.
Mediation failed. Report has come, mediation.
No, that is what is that application I'm looking at page number 19.
I'm sorry, 110 minutes. My
110?
application is at 110. 110 minutes. My request is to grant me permission for tendering evidence, chief examination and for
And
cross-examination.
cross-examination.
If the court insists for cross-examination, some date may be fixed. The reason is why I'm saying this, my lord.
That can be done
But
because you're a judicial officer.
121 page.
No, we'll direct the trial court to give you a fixed time frame, a fixed date and at one go, that should be completed. That much the court can.
Cross-examination. Chief examination can take place there through video conference.
Yes.
That can be done.
Hmm.
For cross-examination, if the court feels that demeanor of the witness,
It's not about court feeling. Let it be. Let you be there for the
the
cross.
demeanor of the witness cannot be found out because of video conference. So therefore,
Let you be there for cross-examination of your, this petitioner. We will fix a date for that.
kindly see page number 121, where I am given in charge of 2 or 3 courts. That is my difficulty. I can't appear on all the dates of hearing.
Not all the dates. I said that.
So
we
the
will
court
give a
finds fault with
specific
me, the
date.
court finds fault with me, I'm not appearing before the court. My advocate is present throughout.
Take
Throw-
notice,
throw-
take notice. We will, the petition, it is submitted that the petitioner is a judicial officer. It is difficult for him to appear before the court for his cross-examination. And as such, he filed an application to appear through online. The same was rejected by the court. Considering the submission of the petitioner, he has relied on a judgment of the Honorable Apex Court in,
Of this court and also.
he has relied on the judgment of this court in case of
In the case of T. Veera Prasad
P.G. Veeraprasad
versus.
and others, and Prakash Gandhi and others. Relying on this, he submitted that the court order permitted the petitioner to appear on to video conference for the cross-examination. What are these photographs?
The photographs which I have produced in the trial court that I filed here. No, that's on merits of the case, but that is nothing to do with now, to decide this
The,
application.
in a matrimonial matters, the appearing to online for a cross-examination. It may be difficult for the other party to elicit the true facts. But considering the fact that the petitioner is a judicial officer, the court needs to court has to fix a particular date, that is 1 or 2 days as per the requirement of the respondent, and shall complete the same. In that view of the same, the issue notice to the respondents, and there shall be stay of all further proceedings in so and so for a period of till the next date of hearing. Petition is permitted to take out notice on the counsel appearing for the respondent, and shall file a memo to that effect by 12th of September, post this matter on 18th of September. That day will dispose of.
Hello.
Then number 7, court-ordered matters. Banu Prakash VG. Yes, Raj Prabhu for respondent.
PM for the respondent. My lords, the matter in the Supreme Court will be listed on 9th or 10th. So in 9th or 10th. Any date after 12th may be good.
Submitted that before the Honorable Apex Court, the matter is going to be listed on 9th of September, post this matter on 18th.
Yes, my lords.
18th. Yes, next.
Then number 8 for admission. Yes, Kalyan Basalraj. Complaint. V.V. Mallareddy.
A suit for declaration and possession, my lord. The defendant makes an application under Article 39 rules 1 and 2, restraining the plaintiff not to take any advertisements with regard to the pendency of the suit. That application came to be allowed, as against which I am before your lordship.
What is your suit for?
Suit for declaration and possession. Occupancy rights were conferred on my mother 40 years back, that I attained finality. One of the contestants who lost the battle before the land tribunal, taking advantage of the revenue entries, created a document purporting to be a deed of partition. Thereafter, conveyances were effected. Ultimately, there is a conveyance in the name of defendant 5 to 6.
Please come to the impugned order.
Please, ma'am. May I take the last, the findings recorded by the learned judge at page 25. Discussion.
No, it is on order 39.
Yes. It is defendant's application.
No, you said defendant
sorry
has
for-
filed the IA.
Sorry for correction, please, madam. Sorry. The plaintiff has filed
IA for-
the suit,
And
and in
injunction.
which he has filed an application under Article 39 rule 1 and 2. So praying for a restraint order not to alienate the property. So
Sorry.
we are in possession and
That
we
is
are in
granted.
occupation.
That is granted.
No, that has not been granted, that is rejected. Against which
The plaintiff is before the court.
I'm sorry, I'm mistaken. Kindly grant me a date. I'm
Wrong file you are
yes,
having.
yes.
At the request of non-counsel.
2 weeks, madam.
Poses matter on 19th of September.
Then number 9, Neha Nagraj for appellant. V. Sundar Raman for respondent.
Director has to file an affidavit. That affidavit has been filed. That is with respect to where the corpus fund, my lord, is kept.
Where is that?
Filed it, not yet.
Filed. When was it filed?
Saturday, my lords. This
Today.
week of minutes.
Yeah. Affidavit, I think. 31st of August.
I think.
Give a copy of it. Let's see what.
Same thing.
So other signed and notarized.
Not there.
Can be passed on.
think it's all filed along with the petition.
I have another copy note I can pass.
Take that. You have a copy?
I have a copy. There's a. Para 3. Honorable Court by order dated 13A has directed the respondent to file an affidavit detailing with regard to appellant association, how much of the corpus fund that is lying with them and the details of the bank account before this court. For the total amount of 5 crore 89 lakhs. And that having been kept in a resident simple fixed deposit is produced.
Yes.
As far as the receipts are concerned, so the Lordship may kindly see the receipts. They have produced 4 receipts. All of these 4 deposits have already expired in July. It was a 6-month FD that was deposited in Jan of this year. They've all expired. So I'm not aware if this has been renewed subsequently because the receipts that have been produced are already outdated. So as far as this affidavit is concerned, I have no objection. Just that let them renew the FD and produce those details before the trial court as and when they're renewing it. That is all I'm asking for. That will If file it's I have no difficulty if they want to do it 6 months, yearly, annually, biannually, I have no difficulty. But let that be clarified before the court. Let us be aware of it. That's all. Because this receipt itself is already outdated. 11th of July, it's already been outdated. They have not produced the renewal from 11th of July for the next 6 months.
That will file it in the civil court.
That's what I'm saying. Let them, as and when they renew, let them file it before the civil court. That's all I'm saying.
Please come. Where is the impugned order? Page number.
Impugned order is page 43.
Twenty-three.
43.
Agreed with orders passed in. I number 1, invoice number 685 of 2024. Whereby the trial court had dismissed the application filed with the plaintiff on or 39 rule 10 with section 151 CPC. The facts of the case are agreed thereby the plaintiff is before this court. The facts of the case are the plaintiff have instituted the suit seeking cancellation of portion of clause 13 of the sale deed executed by the defendant in favor of plaintiff numbers 2 to 12 and for consequential relief of declaration to declare that plaintiff number 1 is entitled for corpus fund collected from out of the sale of 472 apartments comprised in towers 1 to 5 of B scheduled property and to direct the defendant to transfer the entire corpus fund to plaintiff number 1 association and also for consequential relief of injunction. In the said suit, the present application that's IA number 1 is filed, directing the defendants to deposit the entire corpus fund amounting to rupees 5 crores 91 lakh 68,400. Is the case that the defendants in the capacity of trustees presently hold said funds and this application and by way of this application, they want the defendant to deposit the amount before the court pending disposal of the suit. It is a grievance of the plaintiff that the plaintiff number 1 association established and commences functioning from 1/4/2021. Defendant also executed a handover deed on 12/3/2021 with plaintiff number 1 association, confirming handing over of assets and facilities and amenities situated within the present of 1A and 1B areas of plaintiff number 1 association under the deed. But the corpus fund was not handed over to the association formed by the purchasers. There is a clause in the sale deed it states that at the time of execution of the sale deeds in favor of purchasers, defendant unilaterally changed the agreed terms of sale agreements after having received significant portion of the amount under said sale agreement. It insisted that the amounts would be handed over to an apex association. Now, by virtue of this suit, they want that particular clause, that is clause number 13 of the sale deed to be cancelled and sought for a declaration. According to the plaintiff, the clause is against the interest of purchasers of flats in towers 1 to 5, liable to be cancelled, and sought a direction to the defendant to deposit the amount collected from the flat owners. The defendants have filed a detailed objections to the application, contending that the same is not maintainable. And the provision is also not applicable to the plaintiff. The expression employed in or 39 Rule 10 CPC is party, which means a party to the suit. To apply said provision, one party must admit that it is a trustee for another party to the suit. And therefore, between the parties to the suit, the court may direct either party who is holding the money in trust to transfer money to the other party, deposit the money in the court. It is a case of the defendant that such a provision has no application to the facts of the case. As per the term, as per clause 13, the defendants the money will be held by the defendant until the apex association is formed. And as of now, the said apex association is not formed. The trial court had dismissed the application filed by the plaintiff. While dismissing the application, the court has observed that the words employed in Order 39 Rule 10 CPC is that if the money or some other thing capable of delivery and any party thereto admits that he holds such money or other things as a trustee for another party, or that it belongs to or is due to another party. In such circumstances, the court can direct such party to deposit or provide security to the amount before the court. Admittedly, as per the terms of the sale agreement, the defendant holds the amount on behalf of the apex association, which is not a party in the present proceedings. Even after completion of the development work in the A schedule property, the plaintiff fund is not entitled to seek refund of corpus fund from the defendant. Instead, it should be handed over to the apex association. The court had referred to the clause number, has referred to section number 5 of Karnataka Ownership Flats within brackets Regulation of the Promotion of Construction, Sale, Management and Transfer Act 1972. The court also observed that the defendants in their objections have not admitted that they are holding the amount as trustees on behalf of plaintiff number 1. That in order to make an applicable use of Order 39 Rule 10 CPC, there should be admission on the part of defendant and the nature which would constitute sufficient admission after Order 12 Rule 6 CPC. Hence, the court has come to the conclusion that the application that is filed by the plaintiff is not maintainable and accordingly dismissed the same. aggrieved thereby, the defendant is before this court, then counsel appearing for the appellant plaintiff submits that. As far as the petitioners association, appellants association is concerned, the entire, they've occupied the premises and they have handed over the premises to the purchasers, and they have been managing the same. The corpus fund, which is lying with the defendants, is not so far handed over to the flat owners, in spite of their repeated requests. It is submitted that clause that is incorporated, that is clause number 13 in the sale agreement, it's contrary to the interest of the purchaser. And they're very much worried about the corpus that is lying with them. Next, the trial court, without considering the scope of or 39 rule 10, I dismiss the petition. Next, the senior counsel appearing for the respondent defendant submits that as per the clause number 13 of the agreement, once all the construction is completed, an apex body will be formed, and the corpus fund has to be transferred to the said apex body. It is submitted that the apex body is not a party to the suit, and so far it is not formed.
Okay.
And so far,
Construction audit completed of two
as
blocks.
the construction is not completed, the apex body is not formed. It is not open for the plaintiffs to say that an agreement, sale agreement, the sale deed, a particular clause where it is signed by both the parties is not binding, and the same has to be cancelled. He submits that in this case. Order 39 rule 10 has no application, and the court had rightly dismissed the application filed by the plaintiff. Next one. When this matter came up on (13/8/2024), considering the submissions made on behalf of both the parties, this court has passed an order directing the respondent defendants to file an affidavit with regard to the plaintiffs association. How much is a corpus fund that is lying with them, and the details of the bank account before the this court. The question to the order passed by the court, an affidavit is filed before this court, wherein it is stated that para number 4 of this extract. According to them, the said amount is lying in a fixed deposit. In response to that, land counsel appearing for the plaintiff submits that the deposit is for a period of 6 months, and that is expired long back. And now they have to file a fresh receipt before the court. It has come. They have to file a fresh receipt before the court, before the trial court, after the fixed deposit is renewed. Having in the light of the above, having considered the case of both the plaintiff and the defendant, as far as the application that is filed by the plaintiff under order 39 rule 10 is concerned, the trial court had rightly held that as the apex body is not formed and as it is not before the court, the same is not applicable. However, the fact remains is the corpus fund is lying with the defendants, and taking into consideration the concern of the plaintiff with regard to the said amount, this court has directed the defendant to file an affidavit before the court, and The said affidavit is taken on record, and accordingly, the petition, the MFA is disposed of, directing the defendant to file the revised FT. What is it called? Revised?
They're called deposit.
Revised, revised.
Deposit confirmation is what.
The said account before the trial court.
It may be as and when they renew, and not just this occasion, every subsequent.
Till the
occasion that they-
disposal of the suit,
Till
after every, whenever the, after the same is renewed, time to time, they should file the same before the trial court.
Great.
Yes, ma'am.
Till number 10, Manjunath HR. For appellant.
Pass over, next level.
Till number 11. Chandrappa V.
No representation on behalf of the appellant. Post this matter on 15th of October.
Till number 12, adjourned. 13. Prakash Angadi.
Pertains to National Highway.
National Highway.
Covered by judgment of the Saman.
Hmm?
Covered by the orders of the Saman.
Take that. Same batch.
As against 1,50,000, they have awarded 1,80,000.
Same. The figures are anyhow not mentioned in this, same order. Take that, that order copy is there. Yes, next.
Till number 14.
The definite mind.
HP Ganesh Gowda.
This against the trial or trial court order for not granting the injunction order against our.
What is the suit for?
Suit for declaration, position and injunction. We are the actually first purchaser.
Dispensation of.
The party from the.
Dispensation of?
One.
Huh?
R3.
Give that, take that. The memo is filed seeking dispensation of notice to respondent number 3, SLAO, Special Land Acquisition Officer, since no relief is claimed and is a formal party. The memo is taken on record. A notice to the respondent number 3 is dispensed with at the risk of appellant. Yes.
My lord, I'm the first purchaser. I represent, actually, we are the original grantee was one Mr. Muniappa. Muniappa died during 1989. His legal heirs was.
1983 land was assigned to Muniappa.
Actually, this property was granted by the then City Improvement Trust Board, Bangalore, way back to 30th July 1973. This CITB is the successor to the
1973 in favor of Muniappa.
Muniappa.
Then
It is actually the City Improvement Trust Board is nothing other than formerly the successor to the current Bangalore Development Authority, mine.
Yes.
And actually this grant, as per the document, this lease actually other non-ownership period is only 10 years from 30th for 19.
there is a non-alienation.
Non-ownership period of 10 years.
So that will complete by 1983.
83, my lord.
Hmm.
At that, during the, Muniappa died during 1989 in between. His legal heirs, Venkatamma and her children, Venkatamma, Venkatramu, including her daughters have signed this sale deed agreement during 8/4/1992.
Agreement of sale in favor of the plaintiff.
Agreement for sale deed. Sale deed. Sell this property.
Sale deed or agreement of sale?
Agreement, this is agreement of sale.
Agreement of sale.
Agreement sale.
Date.
On 8/4/1992.
In favor of the plaintiff.
In plan of the plaintiff. Plaintiff, Nanjappa. I represent Nanjappa, my lord. But in between, Bangalore Development Authority, who is the successor, issued the possession certificate on, actually, on 4/9/92. Again, in the possession certificate, they mentioned
Possession certificate is given in whose favor?
in favor of Venkatamma, the wife of
But,
Venkatamma, who is the legal heir.
no, what agreement of sale is in the year 1984? What has happened after 1984?
My lord, agreement of sale is 1992, my lord, kindly correct, my lord. This is agreement of sale 8/4/1992, my lord, 8/4/1992. But in between this.
No, you said the agreement of sale is on 8/4/19?
92.
1992.
Yes, my lord.
Hmm.
And again, this possession certificate issued by the BDA, current BDA, which succeeded the CATB, Bangalore CA, formerly Bangalore.
Understood, yes.
On 4/9/92 issue matter, the possession certificate has been issued in favor of my one Venkatamma, wife of late Muniappa, who is the original grantee, my lord. In that clause, unfortunately, again they mention non-relation period of 10 years. How it can be 10 years once, again 10 years BDA issued. But on the basis of this, after this, we have purchased this property on 18/12/1992. My client, Mr. Nanjappa, has purchased absolute
sale deed.
Sale deed. And again, they have given the full power of attorney also, this property man, on that day registered power of attorney before the sub-registrar on 18/12/1992. Same day, they give full power of attorney to get the documents, everything done. But unfortunately, in between, Venkatamma, the late, who is the wife of Muniappa, has created lull. She has represented the police, Tyagaraja police station. She has lost this possession certificate. She wants a fresh possession certificate. That is under, again, misrepresenting the fact. She has submitted on 21/3/2006. She has lost the Hakkupatra, the possession certificate in English. Accordingly, she has obtained one more possession certificate from the BDA and absolute sale deed in her favor from BDA on, my lord, on actually sale deed on the basis of this duplicate sale deed. She has executed a sale deed in favor of her own granddaughter's husband, one Mr. Srinivasan, who is the first respondent in this. And this is a collusive transaction between the granddaughter and the grandmother. They BDA misrepresented the BDA on and obtained the sale deed from BDA on actually 29th January 2007, my lord. Again, on the same day, this same Munia, after obtaining the sale deed, absolute sale deed from BDA by misrepresenting, she again executed a sale deed in favor of her grandson, that is Munia, her granddaughter's husband, one Srinivasan. That is actually on the same day. Subsequently, further, she has also executed a absolute sale deed. Venkatamma has executed in favor of Srinivasan and Tripula, who is the granddaughter of this Muniamma, and the wife of G. Srinivasan. He is the respondent here. Subsequently, my lord, same property.
Yes.
My lord, actually, further, he has also executed simple mortgage to Raghavendra Cooperative Bank on 9/3/2007, my lord.
Yes.
Our contention is, this is a fraudulent and this is a clouded document. We went before we have filed the suit for declaration portion of the property, since we are the original
What are
purchaser.
you doing from 1992 to 2023?
2023, he has filed a some complaint, some frivolous injunction suit. My client is a slightly uneducated person. He has got a ex parte injunction order. He is not
No,
even
no.
educated. He's a
No. According to you, are
He
saying.
is in possession of the property until 2007, my lord. But subsequently, after this fraudulent transaction, he has created mutations, RTC, everything, and he tried to interfere in peaceful possession of the property of my client. Subsequently,
So then from 2007 till 2023, what is he doing?
well, 2023, only 23 it has started between my client and that.
No, you say that only you are in possession of the property till
From
20 till 2007.
92 to, yes, for record 2013 ವರ್ಗೂ ಇದ್ವಿ, my lord. As even today, our encumbrance says we are in, our Nanjappa is in possession of the
No,
property.
just now you said your client is in possession of the property till 2007. So
Because
what did he do from 2007 to 23?
23, because litigation, so 2012, he has filed a frivolous suit, this fraudulent purchaser, and he has got the interim order, and he is, hence he is not moving that area. Subsequently,
Yes.
subsequently, we have filed a suit for declaration of possession injunction. When we understand that, when you go to the police station, they are given undertaking that we are going to resolve the issue through the civil petition. Then we have filed the civil petition, suit for declaration of possession by paying court fee of 1,51,325 before the trial court. Unfortunately, real trial court is unable to give the injunction order because reason is non-est. Non-est is alienation period, once in any property, once in at a time, not for the 1973, 83, 92, again 2002, all these things will not applicable. Since this is the that has not been taken to consideration by the honorable trial court, and it is not considered our interim order, injunction order. Hence, we are before this other court to consider, at least to put an end to this, with justice for us, because we have submitted all the documents, including police, he has misrepresented, it's a collusive transaction, even suspicious documents have been created, it's a clouded document. When Supreme Court, anytime appellate court ordered, in the cloud, the injunction order should not be granted. The various judgments have been perusing, that if needs, I will submit before this honorable court for consideration. That's why I'm before this court, at least seeking the injunction order.
This is not a case where injunction can be granted. Please come.
My lord, actually, this is a fit case because my client is in possession of the property until 2023, because 123 only we know he has paid he is constructing.
You said you are in possession of the property till 2007 just now.
2007, he has changed the document, but 2003 only he knows, we came to understand because my client is not aware of the, he is not aware of the what is going to happen between the grandmother. Grandmother died during 2017. In that one incident has happened, I have gone to the press also.
What are the documents that are placed before the trial court to show that you are in possession of the property?
Well, we are in possession of the property because they are also, they don't have any possession of the property. Long time, they don't have proof to establish that they have possession of the property.
You have come to the court. You have to prove that, not the defendant.
Because I'm the first purchaser, I'm the true owner, I'm the true purchaser, and also I succeed the property of Muniappa way back to 1992.
No, please tell the court what are the documents that are placed before the trial court.
I placed
show that-
sale deed, absolute
Sale deed will not show your possession. They also have a sale deed.
They only second sale deed, second purchaser. They are second purchaser.
No,
my lord.
please understand, for possession, you have to show something, just like that, basing on that, if you have a sale deed, the declaration will
Only
be granted.
2023, my lord, he started harassing my client. He started uploading the material for construction. We have brought to the notice of the honorable court because they said they have given undertaking before the police. We will resolve the issue by mutual consultation. All these documents are submitted, my lord. When the suspicious document, how the court cannot grant the interim order? We have filed suit for declaration, possession, permit injunction. At least temporary injunction could have been granted for us. Until the disposal of the suit, we have the prima facie evidence that it is a concocted, it is a frivolous, vexatious, pollution, all these things we have proved, we have submitted to before the honorable court, my lord. We have tried, we have done our best to prevail upon the court to consider our prayer. If non-est is not applicable. They have just created, non-est, how many years any non-alleged period will exist, my lord? Once in any property allotted or granted, once 10 years. It cannot be extended beyond that. She has obtained all the process certificate by fraud, by misrepresentation, by suppressing the facts, my lord. When creditor situation, how we, a common, is a illiterate person. He is not even just signing it, no, he's a sanitary worker, he's a large person on the society, I can say. But he does not have even center today also. But this person who has purchased, he is well educated, he is well trained to manipulate all these records. But 2020, even myself then, he started, after my visit to the site only, he started constructing the house. To be honest with you, I visited this site before filing the suit. Site is vacant at that time. He started immediately, he grasped how he may be knowing I may file suit in that. But he is illiterate person, he approached me, how you can help me to at least, I have purchased the property to 1992 with hard-earned money. Since they have created the collusive document, created the record, he is well educated, he is well trained. In Bangalore, this is a common phenomenon we have been seeing, but any unnecessary innocent being victimized, we have put to grave hardship. That is why I will end up justice before his honorable court, consider our prayer in the interest of the, let the trial court conclude by means of that, but let them give the, at least property, injunction also should be granted until the disposal of the suit in favor of us. Otherwise, it will be a grave injustice, a common person who cannot afford even the legal. He does not, unable to do anything other than me. I am guiding him in the interest of justice, in the interest, a large person on the, to be honest, he is a large person. Yeah, I have not informed, he would have come and with a board and he does not even chapel to wear. He has been granted, he has purchased with all resources. He does not have square meals also. Sanitary worker can understand, my lord. He has to go every day, whenever he work is there, he will wait, he will go. And finish the work, he will go and meet this value. This is a question. What is a land mafia? He is a quite well educated, well trained to all these activities. That is a fact of the issue. 2023, it was vacant, my lord. When I went there and when I went and visited, then he started all these activities very vigorously and he started construction very fast. I have submitted photographs of status of the property from time to time before the honorable court, but I thought I may get some justice. I have submitted even the decided citations in favor of me, the honorable appeals court. When there is a cloud, the due diligence has to be taken by the courts. Even I have citations. I don't mind in submitting if the opportunity is given by this court to consider when there is injunction order to be granted. Very careful when it is a state of the property is under dispute, under cloud. It's a clouded document. It's a collusive document. It's a manipulated document. It is a muscle power. It's a money power. He has submitted before even police authorities.
Yes.
Let the trial commence. Let the property should be as it is. Let it decided because we are the first purchaser, is the second purchaser, 2007.
Yes, please don't reiterate the same submissions. I understood your
That is my
submission.
submission, my lord.
Yes, please
More than
come.
that, but this is a fact of the case I have submitted
Yes.
before you. Board and
Yes.
need to
Agree
be
with orders
considered in the
passed
interest
in
of justice, my lord.
IA number 2 of 2023, invoice number 4050 of 2023 dated 18th April 2024. The plaintiff is before this court. The appellant plaintiff had filed a suit seeking a declaration that the plaintiff is absolute owner of the scheduled property which he has acquired way back in the year 1992 by registered document number 2743/9293, block number 1, volume 1616, registered on 24/12/1992. Grant a permanent injunction restraining the defendants or their representatives from interfering with the peaceful possession and enjoyment of the scheduled property. Further, to restrain defendant number 1 and 2, not to change or alter the nature of the scheduled property, and also to restrain them from putting up further constructions in the scheduled property till the disposal of the suit. Along with the suit, he has filed IA number I-2 under Order 39, Rule 1 and 2 of CPC, wherein he sought an interim injunction restraining the defendant 1 and 2 from interfering with the peaceful possession and enjoyment of the property in any manner in the interest of justice and equity. It is a specific case of the plaintiff that the Bangalore City Improvement Trust Board has allotted the land in favor of one Muniappa on 5/7/1973. The defendant number 3 had entered into an agreement along with his successors on 8/4/1992 to sell the property to the plaintiff. So the plaintiff has allotted by the City Improvement Trust Board on 35/1973 for a sale consideration of rupees 87,500 as she was in need of funds for her daughter's marriage. The defendant number 3's husband died on 29/1/1989. After that, the defendant number 3, along with the children, has inherited the said property. The Bangalore Development Authority has reallotted the said plot. The Bangalore Development Authority reallotted to her and executed the property on lease cum sale on 4/9/1992. At that time, the defendant number 3 had suppressed the previous sale deed executed in favor of the plaintiff. And it is a case of the plaintiff that she had played fraud on the Bangalore Development Authority to make illegal and unlawful gains. It is stated that the encumbrance certificate for the period from 1/4/2004 to 15/1/2003 shows that there are no transactions during the said period. The encumbrance certificate dated 3/10/2022 showing the name of the third defendant showed the retraction of the lease cum sale agreement on 3/9/1992 as of 1992. The encumbrance certificate dated 19/2/2013 in Form 15 showing the name of plaintiff for the period 1/4/1992 to 31/3/2004 in respect of the scheduled property showed the date of registration as 8/12/1992 and the sale consideration of rupees 1 lakh. And defendant number 3's name is shown as a person who has executed the document. It is stated that the Bangalore Development Authority has executed a sale deed on 29/1/2007 in favor of the third defendant in respect of the very same property. It is a case of the plaintiff that the defendant, while taking the said sale deed from the Bangalore Development Authority, had suppressed the sale deed dated 18/12/1992. The plaintiff, not the plaintiff, the third defendant had once again executed an illegal sale deed on 29/1/2007, which is registered in the office of the sub-registrar. for in favor of first and second defendant for a sale consideration of rupees 4,99,500. Further, defendant number 1 and 2 entered into a simple mortgage on 9/3/2007 with the bank for raising the loan of an amount of rupees 9 lakhs. Thereafter, the defendant number 1 and 2 filed the original suit number 3133 of 2007 before the 8th Additional City Civil Court, Bangalore, on 17/4/2007 for seeking permanent injunction. The said suit is decreed on 9/7/2012, granting permanent injunction against the plaintiff in this suit on the ground of lack of oral and documentary evidence before the court, coupled with misrepresentation and abusing the due process of law before the court by defendant number 1 and 2. It is the case of the plaintiff that they have claimed before the court that they are in possession of the property when they were not in possession. Basing on the sale deed dated 29/1/2007, the defendant number 1 and 3 have obtained the kata in their name. Now, the defendants are contemplating to start construction owned by the plaintiff. As such, has come up with the present suit. The defendants have filed their objections. The trial court had dismissed the application filed by the plaintiff by order impugned, wherein the trial court has observed that upon careful perusal of averments of plaint documents produced by both parties, it is seen that plaintiff is seeking the interim relief for protection of his possession for the suit scheduled property, when the main relief sought by the plaintiff is for recovery of possession from the defendant. The claim of the plaintiff is virtually in contrast to the relief sought by him. There are contradictory pleadings in the application and plaint. When the plaintiff himself is seeking the relief of possession, it indicates that the plaintiff is ousted of the protection of his possession. Further, no material is produced to demonstrate that from the date of sale deed till the date of filing of the suit, the plaintiff has been enjoying the possession of the suit scheduled property, and even to demonstrate that the plaintiff is in possession of the suit property as on the date of the suit. The revenue documents produced along with the plaint, that is document number 15 to 17, are dated 2007 and disclose the entry of the disclose the names of the defendants number 1 and 2. The court has also observed that the plaintiff unable to clarify its position with regard to the decree obtained by defendant number 1 and 2 in OS number 3133 of 2007. The court has come to the conclusion that the plaintiff has failed to prove the plaintiff has failed to prove that that he's in possession of the property and is entitled for the relief as claimed in the IA, and accordingly dismiss the same.
My lord, what? The revenue record does not entail any right of the property. Revenue record does not confer any right of the property. That you are kindly aware of it.
The aggrieved thereby, the appellant is before this court. Learned counsel appearing for the appellant plaintiff submits that the plaintiff is the owner of the property. He purchased the property, pay back in the year.
He forcibly is constructing without any fear or anything because he has created some documents.
You argued all this. I'll record it. I'll record it. No need to. I remember everything. Now I'll now dictate to her everything you argued.
Sorry.
Yes. He has purchased a property in the year 1992 and suppressing the said fact, the plaintiff, the defendant number 3 had obtained a sale deed from the Bangalore Development Authority. It is submitted that the whole transactions or a fraudulent transaction. Yes, now the defendants defendant number 1 and 2 are going to make constructions in the land belonging to the plaintiff. Plaintiff, unless and until an injunction is granted, the petitioner would be put to irreparable loss and hardship. It is submitted that the trial court had failed to consider the sale deed that is executed and the fraudulent transaction that had taken place. He submits that the court had considered on the revenue entries, and it is submitted that the revenue entries do not confer title on the parties. When he has filed a document, when he has filed a sale deed before the court to show that he is the owner of the property, the court ought to have granted injunction in his favor. He submits that if the injunction is not granted, even if the suit is unnecessarily, it gives rise to the unless the injunction is granted, even in the event the suit is decreed, the defendant it will give rise to multiplicity of proceedings, and the plaintiff would not be in a position to enjoy the fruits of the decree. It is a submission of the land council that the trial court had failed to consider the material that is placed before the court and the case of the applicant in its proper perspective and dismiss the application. Then council submits that the appeal has to be allowed by granting injunction. Next, having heard the counsel for the appellant, peruse the entire material on record. The suit is filed for declaration and recovery of possession. By seeking a relief of recovery of possession, the plaintiff himself is admitting that somebody is the defendants are in possession of the property. When the defendants are in possession of the property, the relief that is sought by the plaintiff by this IA cannot be granted. It is relevant to look at the relief that is sought by the plaintiff in the IA. The relief that is sought is to grant an interim order of injunction pending final disposal by restraining the defendant 1 and 2, their agent, claiming through them from interfering with the peaceful possession and enjoyment of the suit scheduled property in any manner in the interest of justice and equity. If the petitioner with the appellant is in possession of the property, question of the recovery of possession will not arise. The relief that is sought, the trial court had rightly observed that the relief that is sought in IA and the case of the plaintiff and the plaint is contradictory to the other. The stand that both the stands, the stand taken by him cannot coexist. Whether a sale deed is executed in favor of the plaintiff, by virtue of that he has become a owner of the property, whether the defendant has a right to execute a sale deed in favor of defendant number 1 and 2, all these issues have to be considered by the trial court during the course of trial. When an injunction is sought, the burden lies on the plaintiff to show that he is in possession of the property. The relief of recovery of possession that is sought by the plaintiff makes it very clear that he is not entitled for the relief of injunction, and the trial court had rightly dismissed the petition. This court finds no reason to interfere. Accordingly, MFA is dismissed.
Number
My lord,
15.
kindly direct the court to dispose the petition on priority on merits in accordance with the law. This schedule some direction to given it should be disposed in the specific type because you might say.
This is a suit of 2023. There are so many suits pending. Why should there be a direction in this? Supreme Court said that kind of a direction cannot be given.
I'll be put to grave hardship because I don't have.
That can't be, that is not possible, Mr. Senior. Please understand. Next.
Number 15. Subba Reddy KN for appellant.
Respondent number 1, Elevator.
Yes.
Kumar.
For the appellant, filing a memo for retirement. The other counsel is filed the, other counsel has filed the wakalat.
Yes. Take that.
Counsel from Mr. K. Subbareddy's name may be deleted.
Then wakalat is already filed.
Filed in the registry today, my lords, with no objection by Mr. Nagaraj.
Mr. Subbareddy K has filed a memo for retirement. And it is, and then the same is taken on record. And the council is permitted to retire. It is submitted that Mr. So-and-so, give your name.
Nagaraja.
Write it on a paper and give the name. Mr. So-and-so has filed wakalat and he has instructions to appear on behalf of the appellant. Yes.
Lords, this plaintiffs appeal, my lords, against an order refusing, my lords, rejecting the IA for grant of temporary injunction.
Yes.
Suit, my lords, is also for bare injunction suit.
Yes.
But the case of the plaintiff is, my lords, that her mother, Vanchli Gauramma, has bequeathed the property, suit schedule property bearing survey number 64/1, measuring about 6 guntas in her favor, in plaintiff's favor. And that her mother Gauramma in turn, my lords, had got the property by a will dated 6/3/1990 from her brother Vanchli Narayanappa. 6/3, 6th of March 1990, from her brother Vanchli Narayanappa.
And what about this plaintiff?
Plaintiff in turn, my lords, got the her mother Gauramma bequeathed the property
By way
in
of
favor
will.
of plaintiff by way of a registered will on, my lords, 23/9/2016. My lords, the plaintiff's mother, that is Gauramma, had disputes with regard to her other properties, lords, with Narayanappa and their siblings in a separate suit, my lords, in which this
So who is the brother who has executed a will in her favor?
Narayanappa. Narayanappa had executed a will on 6/3/1990.
Narayanappa has executed a will in favor of the plaintiff's mother.
Yes, on 6/3/1990. My lords, then plaintiff's mother has in turn executed a registered will in plaintiff's favor. Then, my lords, the entries had been changed to, there were disputes relating to the entries. The LRs of Narayanappa, that is, my lords, Narayanappa is no more. They had, my lords, the entries stood changed in name of Gauramma. And then the dispute arose before the Tahsildar who had changed.
When Narayanappa died?
Lords, Narayanappa died on 8/11/2012.
8/11/2012.
2012. Gauramma, of course, died. My lord, my mother also died on 10/9/2019.
10/9/2019.
2019. My lords, certain disputes arose regarding the entries.
Mother's will is in 2016.
Yes, my lords. 23/9/2016. Ultimately, entries had been changed to my name or my mother's name.
When?
My lords, those disputes arose, my lords, the Assistant Commissioner and Tahsildar had passed an order in 2015, which they have produced.
Yes, today they have not placed all records, I am placing.
That's all part in the suit. My lords. It's fine whether I
Yes,
have not.
yes,
Yes.
The part of the suit.
Yes, 2015 are the entries.
My lords, anyway, the
In the
matter
name
is dishonorable court in a writ petition, which your lordships should get, my lords. Along with that, they have produced. The lordship kindly come to 139 in their compilation. 139. Running page 130.
Yes.
It's an order of the dishonorable court in a writ petition filed by my mother. But I was the party since I was the LR. That's where I had challenged the order of the deputy commissioner who had, lords, given a finding about the will that revenue entries cannot be changed on the basis of the will. And in this writ petition, my lords, I had taken up a contention that I'll initiate appropriate civil proceeding. Thereafter, my lords, I have filed a P&SC suit to get my will probated. That P&SC suit, my lords, has been decreed on 19th January 2022. That, of course, has not been produced, but it's a matter of record, my lords.
Where there are no other parties.
My lords, I had made, of course, I had made my LRs, that's my lords, my
No, No, will is executed by somebody, they should be the parties. in
Yes,
it.
but a paper publication, unfortunately, a paper publication appears to have been taken out, which is recorded in the P&SC. Now, the will is probated and the probate is granted on 19th January 2022. P&SC is 32 of 2020.
Yes.
That comes after this honorable court's order.
Hmm.
Based on that, I claim title to the property anyway, my lords. I file a suit for injunction, saying that the defendants are trying to interfere with my possession of.
That is children of Narayanappa.
Yes, Narayanappa.
Narayanappa.
Yes. In that, they filed their written statement.
No, let's see your plaint.
My plaint,
Yes.
my plaint is about 2 pages, my lord, please come. Lords,
Page 41.
please come to the plaint which your lordship should get at page 40, running page 40. It starts at 40.
Is that property Narayanappa's self-acquired property?
That's our claim. Now, my lords, up to 43 it's a simple bare injunction suit. Now, my lords, the defendant's written statement, of course, is from page 45, in which they take up 2 primary contentions. One, my lords, that they mention about a suit bearing OS number 8578 of 2016, which is filed
No,
by.
what are the documents to show that you are in possession of the property, the revenue entry? That is.
Revenue
not
entries,
the-
lords, revenue entries which stood in favor of Narayanappa. And later, my lords, it was changed to Gaurama's name, but again changed back
To
by
their
the Deputy Commissioner's order.
What is the nature of the land as on today?
According to us, it is an agricultural land.
Hmm.
Now, the defendants claim, lords,
Let us see their written statement.
written statement is in detail. Lords, in just what they say is, Narayanappa's will itself is a forged will, that they have filed a police complaint, a PCR, in which charge sheet is filed, saying that there is a forged will. They don't say they have filed, they do not contest the will or they don't institute any suit
You have filed any appeal against that?
against the
Probate
P&SC.
that's granted.
P&SC is concerned miscellaneous 501 of 2024 filed. My lord, they filed this injunction suit, disclosed first time after service of.
Then you
summons.
filed a miscellaneous. claim.
Miscellaneous filed in the notice as ordered to them and miscellaneous is pending consideration. My lord, admittedly, suit schedule property is
Let him complete.
yes, sorry.
I will not,
Yes.
I will say whatever,
Yes,
everything,
sir.
my lords, I'll have to reveal.
Yes.
Now, in that, one is on the forged will of Narayanappa is one contention. The next contention they have taken is that my mother, that is Gaurama, had filed a suit bearing OS number 8578 of 2016 against Narayanappa and her siblings, claiming partition, my lords, and share in the properties. And without revealing that suit, she has got P&SC probated in her favor. Now, my lords, and also they claim they are in possession and they have sold bits of properties of this very same survey number by way of sale deeds to certain private parties.
Which year is the sale deed?
My lords, the sale deeds which they claim to have executed is in 2023, my lords, 19/10/2023, subject to correction.
Yes.
Hmm.
Page 1.
Now, my lords, the sale deeds are also, and the suit, please see the amended plaint which they have filed, which would support me, which is at page 145. It starts at 145. They, lords, I am fortunate, they have produced it. It starts from 145. The plaint that had been filed by my mother, Gaurama, in OS 8578 against Narayanappa's. Your lordship gets that. my lord.
Yes.
Please come to the schedule in that suit which your lordship should get at running page 115, 8. From 158, the suit schedule property start.
Hmm.
But if your lordship sees, in all this, there are about 7 items. 64/1, which is the present suit schedule property, is not a part of that. So our claim is that this suit has no bearing so far as this scheduled property is concerned. That's that's all what I wanted to point. Now they say they have sold the property to purchasers and they have produced a sale deed. If your lordship sees the sale deed also, one of the sale deeds at 183, it starts. Now this is an agricultural land.
Yes.
It starts at 183.
Yes.
My lords, if your lordship kindly come to the schedule therein, which your lordship should get at page 199. Without the layout, the land being converted for non-agricultural purpose, without a layout plan being approved, they show a site number 64/1A to one person. To another person, they say it's 64/1B. Now there is either no layout plan, no conversion order, and they say sites have been formed. Now, if they have sold, they can't have any grievance so far as the injunction being granted. It is for the purchaser to come and oppose me.
Yes.
Now the court, my lords, court below holds that there are several disputes, and this is a matter which has to be tried at the trial, and at the present, injunction cannot be granted. But they have produced photographs to show the construction is on the line. I'm only saying an equitable relief should be lords, if anybody is putting construction, they can't.
Not the purchaser.
No, they are not.
They have sold the property.
Milord, I am appearing for the landowners, Milord,
Then
who have sold. Respond.
others need to be served.
Milord, I will undertake to file wakalats for all, because I am the trial court. I appeared on behalf of all the respondents. David only filed for one respondent. Now I will undertake to file wakalat for all the respondents. But
What is that you're doing now in that land?
Milord, the already construction is over. Milord, I have produced the photographs.
What is the construction?
Building, residential building, Milord.
Then you occupy, don't sell it.
Milord,
You can occupy, don't
It's
sell.
not
already,
They are saying
Milord,
purchasers,
only,
sir.
Milord,
Whoever it is, let there not be any further, till the cases, it's a residential building.
Milord,
You have purchased, which you have constructed for residing in that.
yes, Milord. For the residential purpose, we have purchased and we constructed, construction is completed. Suit for bare injunction. Milord, prima facie case, Milord has to show as on date of filing of suit, whether they are in possession or not. Milord, in order to appreciate that, admittedly, these lands, Milord, comes under the within the jurisdiction of BBMP. The lands, Milord, has been
Where is
lost
the- So where is the question of injunction when other parties?
yes, Milord,
He-
that's only.
He is
Milord,
not the purchase, my lord, now
It is not even a suit for declaration and injunction.
my lords, are only bare in, that's why lords, I said it's only a bare injunction suit.
Suppression of facts,
Yes,
they are
yes.
not entitled to anything.
Yes.
Purchasers are not.
Suppression of fact, first of all,
Allah.
they're not. in
Yes,
possession.
Milord. First of all, they are not entitled. They have suppressed all these sale deeds because these
But
sale
I
deeds
don't-
much earlier to filing of the
Sale
suit.
deed to which I am not a party, my learned friend says, he was not aware of P&SC suit. I cannot be aware of a sale
Not-
deed sold by them, in which I am not,
Once-
and as.
Deemed.
Not once,
Everybody is,
The act.
my lords, it's,
not once the,
both brothers' families are fighting. There is a will in my favor.
not
which
the,
They have not challenged by instituting a suit, but have gone in
We could understand this is a suit for declaration, but it's a bare injunction.
not-
It's a bare injunction.
He is in possession of the property. Where is the question of
Yes,
direction?
Milord.
Any other direction to him?
But he claims he has sold the property.
yes.
Let ABCD be in possession, but not the plaintiff.
Lords, we claim to be in possession by virtue of
Then
the.
You don't require, then all these, what about the photographs and all?
Lords, that of course, then my lords, whether I leave it to at that, my lords, then
Yes,
nobody
yes.
can claim equities is my. Because tomorrow somebody will claim equity having put up a construction knowing fully well. That should be, my lord, because he is putting photographs of his purchasers.
What is the equity in a suit for injunction?
Yes.
Lords, we might amend, my lords, ultimately somebody has to amend. Either they have to file a suit or I
At this
have to.
time, you have to amend when they are denying your title to the property.
Lords, I have, lord, somebody comes and says, I have no title. That will not.
And
amount
basing
because
on,
I am-
it's not there when they have raised a cloud over the title of the
Lords,
plaintiff.
I can understand Bucci Reddy's case, but claiming the cloud over my title, they have not instituted any proceedings on the will executed by Narayanappa.
That's why they have instituted the proceeding now by a miscellaneous petition.
That's my lords, that of course, that is my mother's will to me.
No, with
My-
all this probate and all, I think it's complicating the things more.
Milord,
Simply neither, no other party paper publication, take something and
I leave it at that.
only page 139 will answer to all the questions, Milord.
Page
139,
number?
page number 139, Milord.
of your papers.
Yes, Milord. Milord, the order passed by this honorable court in the writ
That's
petition.
why I showed your lordships that.
Milord,
Justice Shyam Prasad.
yes,
order.
Justice Shyam-
wherein the, Milord, they himself sought liberty at the time of disposal of the dismissal of the petition. They will go and file the appropriate civil proceedings. They have not disclosed
What, the civil
suppression,
proceeding?
that's why, Milord.
Probate.
Yes,
Civil
Milord.
proceedings is
Yes, Milord.
probate.
Probate So they are aware we are contesting parties from the forged will of the Gauramma. Gauramma will itself is a forged. Where is the question of she executing, bequeathing the property to the daughter, and she claiming right over that property is the question.
Why?
Yes, Milan.
Unnecessarily.
Yes, ma'am.
The agreed with the orders passed in I number one, in OS number 1527 of 2024. Dated,
But may I just take the-
yes, dated 29 June 2024. The plaintiff is before this court. The appellant plaintiff had filed a suit for injunction. So, filed a suit for bare injunction, restraining the defendant from interfering with the suit scheduled property. It is a case of the plaintiff that the plaintiff is a absolute owner of the property in survey number 64/1, Highly Village, Kasaba, Hubli, Bangalore. And the plaintiff is in peaceful possession and enjoyment of the property. The property was bequeathed by her mother through a registered will dated 23/9/2016. In turn, that property is bequeathed in favor of her mother by one Narayanappa, who is the brother of
Gauram.
her mother,
Yes.
brother of her mother. And thereafter, the plaintiff had filed P&SC number 32 of 2020. And the court had, and an order was passed on 19/1/2022. By virtue of that, plaintiff has become the absolute owner of the property. Plaintiff is in possession and enjoyment of the property. Defendants are unconnected with the suit scheduled property. And without any manner of right and title, the defendants are interfering with the peaceful possession and enjoyment of the property of the. It is a case of the plaintiff that when high-handedly defendant started interfering with the property, she approached the jurisdictional police to lodge a complaint. The police have not registered the complaint against the defendants, stating that the matter is civil in nature, and advise the plaintiff to approach the civil court and get an order of injunction against the defendant so that they'll help the plaintiff. As such, she has come up with this application. Then IA number 1 is filed seeking injunction, wherein it is stated that reiterating the very same stand that is taken in the plaint, sought for an injunction. The defendants have filed their detailed written statement, wherein they have defendant number 1 filed, or all the defendants filed.
Defendant 3 and 4 filed, others filed memo for adoption.
Defendant number
3 and 4.
Defendant number 1 is the son of Narayanappa.
D1 is not the son of Narayanappa, my lord.
So
Narayanappa is no more.
No,
Narayanappa's
then
sons, other yes, my lord.
who are the defendants of?
The
heirs of
defendants are, my lord, are the sons, para, page 46 of my written statement, kindly look at, my lord. Page 46, para B, my lord, 46B, 5B. Defendant submit Narayanappa died on 8/11/2005, leaving behind his 7 children, that is Venkateshappa, that is defendant number 3, and I have described.
No,
46.
please come to the cause title of
Yes, my lord.
the plaint, come to the plaint.
Yes, my lord.
And tell the court from that.
Yes,
what-
my lord. The Narayanappa's first one is grandchildren, my lord.
Defendant number 1 is a
Is-
grandson of Narayanappa. Defendant number 2,
2 is son,
3, 4
4,
are the sons of Narayanappa.
6
Fifth is the fifth, sixth
are the daughters.
defendant or the sons of Narayanappa. daughters of Narayanappa, and 7 and 8.
They are the agreement holders they made, my lord. One
Seven and-
is only agreement holder, others are the family members.
Hmm.
Yes,
Defendant number 1 is the agreement holder.
Yes, my lord.
Delete all that. Defendant number 1 is the agreement holder, and 2 to 14 are the family members.
family members of Narayanappa.
Family members of Narayanappa. They have, the defendant 3 and 4 had filed the written statement, and which is adopted by other defendants. It is their, they have disputed the will that is granted, that is, they disputed the will that is alleged to have been executed by Narayanappa in favor of the plaintiff's mother. It is their case that their father, the Narayanappa, is the absolute owner of the property. And being the legal heirs of Narayanappa, they have succeeded to the said property. It is stated that when earlier the name of Gaurama was mutated in the revenue records, they have filed an appeal before the revenue authority.
Not like that. No, it was named in the name of the LRs of Narayanappa. Gaurama filed an appeal before the revenue
Then
authorities.
Gaurama filed an appeal, no, not before this court.
Not before this court. In the first revenue appellant.
When the revenue entries are there in the name of Narayanappa, and he says, the mother of the defendant had filed an appeal. And when that appeal came to be dismissed, again, is that a writ petition is filed before the,
Again, it's that revision petition filed
that is
before
also
DC.
dismissed.
That was
Again-
set aside because appeal was allowed. Appeal was their favor. We challenged that order before the DC. DC was set aside that and
Understood.
confirmed the.
Appeal is filed. In the appeal, the entries in the name of Narayanappa were set aside. Aggrieved thereby, the legal heads of Narayanappa had filed a revision. In the revision, the order came to be set, the order passed by the appellate authority came to be set aside. Then the defendant, the plaintiff's
Mother.
plaintiff's mother had filed a writ petition before this court, page number
158. 162, sorry.
filed a writ petition before this court, that is WP number
That is 139, my lord, 13942 of 2019, 139 page number. 13942 of 2019.
filed WP number 13942 of 2019, dated 13942 of 2019, and that came to be disposed of on 19th November 2020, wherein this court has observed that wherein the writ petition is disposed of with liberty, subject to all just exceptions in law, to the legal representatives of the original petitioner, Srimati Gaurama, to institute appropriate legal proceedings and in law, appropriate legal civil proceedings. It is the case of the plaintiff that, it's a case of the defendants that they have no manner of right or title with regard to the scheduled properties. And you have stated so about the constructions also in
Yes,
the-
my lord.
it
Photos
is
produced before the
Page
court.
number, which
Page-
para number?
Lord, para number, written statement, 51 page may kindly look at, my lord.
Hmm. Yes,
The 49 I may kindly look at, my lord.
40?
49, page 49.
Hmm.
These defendant submits that from the date of purchase of the above said purchasers are in
Yeah,
possession and
They
enjoyment
have
of
they
their.
have entered into an agreement with defendant number 1.
No, my lord, sale deed. We are the purchasers of the property. Our sale deed also.
Who are the purchasers?
The defendants 2 to 7 have sold the property to the 3 purchasers. 3 purchasers are in possession. The respective sale deeds, my lord, have placed
In the
before the trial
context,
court.
in the case of the defendant number 1 to
2 to 14, all have sold the property.
in favor of defendant number 1.
No, even not. 1, 3 purchasers. That is, they are not made as a purchasers. 1 Srinivas, 1 Monisha. The sale deeds I have placed in my written statement. I have disclosed about the purchasers details.
So the purchasers
That
are
was not a
parties.
parties in the suit at all.
Have sold the defendant numbers, defendants 2 to 16.
Yes, my lord.
Have sold the property in favor of 3
1 Srin,
persons.
yes, my lord.
And they have been put in possession of the
Yes, my lord.
property, and they have also started construction. And they were not arrayed as parties to the suit. That is in their, in the written statement, what is stated. It is, they have also stated that after they have sold the property, the purchaser has raised, have constructed a residential building in the said premises. And the defendant, the plaintiff is not entitled for a relief of interim injunction. The trial court had considered the application filed by the plaintiff, and the trial court had dismissed the same. While dismissing the said application, it is observed that the trial court has observed with regard to this, the documents, the sale deed, the will, and other proceedings with regard to the entries in the revenue records. And the court observed that while considering an application for grant of injunction, the court will not only take into consideration the basic elements in relevant to existence of prima facie case, balance of convenience, and irreparable injury, it must also take into consideration the conduct of the parties grant of injunction is an equitable relief. The court has felt that the partition suit that is instituted by the defendant was not stated before stated in the plaint. And considering all these, the court had dismissed the application, and the court has felt that there is no prima facie case in favor of the plaintiff. Plaintiff, aggrieved thereby the plaintiff is before this court. Then a senior counsel, Mr. K. N. Fanindra, appearing on behalf of the appellant, submits that the bill is executed in favor of the defendant's plaintiff's mother in the year 1993.
90.
Huh?
1990, my lord.
6/3/19?
90.
90.
90.
6/3/1990. Ever since the set date, the mother is in possession of the property. In fact, the revenue entries were changed in her name. He submits that he has also filed a probate, and the court had, and an order was passed in his favor. Passed in her favor. Passed in her favor. It is submitted that they've been in continuous possession of the property, and the respondent, defendant are interfering with the same. Hence, they have come up with a suit for injunction. The court had failed to consider the will, the probate, and other documents that are in favor of the plaintiff, and without appreciating the evidence on record, had dismissed the IA seeking interim injunction. It is submitted that unless and until an injunction is granted, the plaintiff would be put to irreparable loss and hardship. Next paragraph. Learned counsel appearing for the, you filed
For respondent one, I filed caveat.
Learned counsel appearing for the defendant number one submits that he had filed he had filed a caveat on behalf of defendant number one. He is appearing for all other defendants before the trial court, and he has instructions to file wakalat on behalf of defendants respondent numbers
2 to
2
14.
to 16.
14.
14. Defendant number 2 to 14. Then counsel submits that this court, when they have questioned the revenue entries in favor of Narayanappa, and in an appeal, when they were set aside, and when the entries of Narayanappa are set aside, again, is that an revision is preferred. In the revision, the order of the original authority is revived. Aggrieved thereby, they filed the writ petition, and before this court, it is submitted that the writ petition is disposed of, permitting him to avail the appropriate remedy. And counsel submits that when they are contesting when there is a dispute with regard to this entries, without the knowledge of the defendants, they have obtained the probate. Now they have filed a miscellaneous petition to set aside the order passed by the court. It is submitted that at every step, there are suppression and misrepresentation of facts. And the trial court had rightly held that the plaintiff is not entitled for the equitable relief of injunction. He submits that when they have filed the photographs to show that the defendant is in, that the constructions are made and the subsequent purchasers have already constructed the house, that itself shows that the plaintiff is not in possession of the property. When it is a suit for bare injunction, and when the defendant is denying the title of the plaintiff, and when already the purchaser is in possession of the property, the defendant is not entitled, the plaintiff is not entitled for any injunction, as prima facie his position is relevant for granting an order of injunction. He submits that the court had rightly considered and dismissed the petition, and no grounds are made of seeking interference with the well-considered order passed by the trial court. Next slide. Having heard the counsels on either side, there is a material on the court. This is a suit for bare injunction. The source of title to the defendant is a will executed by her mother, and the source of title to the mother is a will executed by her brother. And with regard to, and when basing on questioning the revenue entries in favor of her brother, when the defendant mother had filed an appeal, when the same was when there was an order in his favor, the same was carried in revision, and in the revision, the order of the primary authority is restored. Against that, a writ petition is filed. As rightly contended by the counsel for the respondent, when there are disputes pending between the parties, they have filed a probate and obtained a probate without the knowledge of the defendants. When the whole dispute is with regard to the will that is executed by Narayana Appa, according to the defendants, that is a forged document. In respect of that, they have already given a complaint to the police, which is registered
CC charge sheet filed.
Which is
Not CC, that
registered,
also placed
and
before
a
the-
charge sheet is also filed by the police after a fledged investigation. Then the defendant had filed a suit. Defendant or defendant's mother partition?
Plaintiff's mother has filed.
Plaintiff's mother or plaintiff?
Plaintiff mother filed initially. suit
Plaintiff's
for-
mother had filed a suit for partition. In that suit, the suit schedule property is not part of the said suit schedule. The court had taken note of all this and has come to the conclusion that the plaintiff had not come to the court with clean hands. When a person comes to the court seeking an injunction, he has to prove that the prima facie case, balance of convenience and irreparable loss. And the sine qua non for granting injunction is the possession. In this case, the plaintiff himself is not in possession of the property as the defendants have filed the photographs to show that the subsequent purchases have raised the construction. Without going into any of the merits of the matter, that itself is a ground where the plaintiff is not entitled for injunction. In this case, the defendant had, now the plaintiff had no, plaintiff is not having the possession, and the defendant is denying the title of the plaintiff in respect of the suit schedule property. So suit schedule property. Now, in those circumstances, the plaintiff is not entitled, because I do not want to give any finding on that.
Yes.
In those circumstances, the plaintiff is not entitled for the relief of injunction, and the trial court had rightly dismissed the petition. This court finds no reasons to interfere. Accordingly, dismissed. take another printout. Yes, next.
Cell number 16. Chandan K. Chandan K. For appellant.
This is a defendant's appeal, my lord. Suit is for specific performance that has been filed by the plaintiff. So the facts of the case is the appellants are developing the residential apartment
You're the
project.
defendant.
We are the defendants before the trial court. The appellant is developing a residential project called Century Horizon in survey number 4P2, which is now municipal number 479/4P2 at Jakur Plantation, Yelahanka, Hooghly. And various apartment units have been put for sale. Now, my lord, this apartment unit bearing number 214, one Pamela Chatterjee approached the appellant, and with her there is an agreement executed on 3/6/2022 for a sale consideration of 1 crore rupees for the apartment. And she has also paid an advance of 2,55,000 rupees, and further amounts are being, as per the progress of the project, further amounts are being paid. That is one part. When this being the situation, the appellants receive suit summons with respect to the suit wherein the defendant has filed a suit, claiming that she has entered into an agreement with respect to the same apartment unit bearing 214. And she says that she seeks specific performance of this particular agreement to sale.
Now, two people claim specific performance in respect of the same.
No, the earlier one, the one Pamela Chatterjee with whom
You have entered.
we have entered into an agreement. Still the stage has not resumed because the construction is still going on, and even as per RERA, till the end of 2024, we have time for completing the construction. Now, this lady Suma claims to have entered into an agreement, which we say it as a forged document. Dated 16/7/2021.
And according to her, what?
And
are the
according
amounts?
to her, the total sale consideration is 84,94,000. And she claims to have paid an amount of 60 lakhs out of that, 84,94,000.
How?
She doesn't mention that, no document to that effect. My lord, I would like to take your lordship to the plaint averments. Plaint is at page 107.
Yes.
And the plaint starts from, that is the index, and plaint starts from 108. My lord, para 4 she starts. She says that some representatives by name Harish Nagaraj and Santosh approached her, and they offered to sell that apartment unit to her. And at para 5, she says she paid, instead of saying paid, she says she invested a sum of rupees 60 lakhs and booked the flat in Century Horizon. The receipt of this amount was acknowledged by the first defendant through official email dated 13/7/2021. That email is also not part of the documents.
Not filed.
No. That email is also not part of the document. Nor she produces any, she doesn't even say how she has paid, whether she has paid by cash, whether if she has paid by cash, how, where is the receipt? Nothing. She doesn't say that she has paid by check. No one would pay an amount of 60 lakhs by cash. That too during COVID 2021 time. And there is no document to show how she has paid, and she refers various emails.
That also not part of the record.
None of the emails is the only thing that is part of the document. I'm sorry, my lord, while filing this, I did not file the list of documents by oversight, which I'm producing it. The list of document contains the original sale agreement and a legal notice that they claim to have sent, and a postal receipt and acknowledgement. Apart from this, no other document.
Legal notice dated?
Legal notice is dated 3/3/23.
You have responded to that?
No, my lord, we have not received any such notice.
You say that there is an acknowledgement.
They say that there is an acknowledgement, but we have not, because from the agreement, we are saying that's a forged document. None of us have signed this document, nor we have received any amount.
This is an that you have received it at your address. What it
My
says.
lord, I do not have any instructions on that because the claims, even in the written statement, they have not said anything about that.
Hmm.
But the important fact here is a person who claims to have paid 60 lakh rupees
Hmm.
doesn't say how he has paid, no bank statement, no check details, nothing of that sort.
Hmm.
And she claims to have sent certain emails, my lord, at paragraph 5. She says, one, there was an official email acknowledging the payment on 13/7/21, which is not part of the
That's a
document.
crucial document.
My lord,
That's a crucial
that's a
document.
crucial document, which is not part of the
No.
compilation.
Now,
Then
please
she
come to
says,
the order.
my lord, yes. The order is at page
32.
32, my lord. The only reason why the court appears to have granted an interim order is on the ground that there might be multiplicity of proceedings. My lord, I would like to take your lordship to paragraph 8 at page 34. Plaintiff contended that she filed a suit for specific performance of agreement of sale against defendants in respect of scheduled property. But even though she is ready and willing to pay the remaining amount,
We'll dispose of the main MFA itself. We'll give a short date if you can take out notice to the council
do
for
that,
the
my lord, but the
respondent.
problem here is they have already entered into an agreement with someone, unnecessarily blocking that property. At the end of the day, my lord, your lordship.
No, it's just a matter of a week. We'll dispose of the matter itself here. We'll
Much
give a
obliged.
date.
Much obliged.
Because unless what is happening is again an interim order, again another
I
order.
am grateful to you.
The post this matter on 18 September.
Much obliged. my lord.
18
And
September,
I may
the
be, sir,
petitioner is permitted to appellant, the counsel to the appellant is permitted to take out hand summons of the counsel appearing for the respondent before the trial court and shall file a memo to that effect by. No, we'll have it on 19th. Memo shall be filed by 18th. If the memo is filed, then list this matter on 19th.
much obliged. You know, the document, shall I file it through a separate memo or shall it be?
Give it. You can file.
I will file it separate memo.
Yeah.
Number 17, Jayprakash Reddy for petitioner. Prasanna Kumar for respondent.
View petition is filed. Earlier, your lordship can see that the respondent filed a MC number 1838 of 15, a decree seeking a decree for divorce, wherein IA number 5 is for seeking a maintenance.
Court officer. I told you how to stop it. Control to you to switch off it. Yes. Yes.
Your lordship can see that your lordship has not considered the judgments which have produced before this court while deciding this petition. What happened in this case, your lordship can see, the trial court had rejected the maintenance in favor of this mother.
No judgments were produced at that time, producing at this time.
Here I have produced the
No,
judgment.
you have, at that time, when the order is passed, no judgments are produced, that's what I'm saying.
No, your lordship can see that was produced.
Ask me, tell you.
Even in the petition, your lordship can see
Hmm.
that the earlier writ petition, my lord.
No, the difficulty here is, that's what I was telling you on the last occasion also.
Yes.
It's not what you write in the petition, what you argue before the court, that the court understands it.
That is true.
And as
But-
far as this court is concerned,
Please.
every argument that is advanced, I'll make it sure that it is part of the order. And I ask the councils also that all the contentions are addressed or not, or noted or not. Yes,
But in writ
Anyhow.
petition, your lordship, in para 20 of the. my
20
gra-
of the,
Original writ petition.
not the writ petition, that's what I'm saying. What is urgent
Yes.
is what is,
That is only judgments was not considered. Your lordship may kindly see now that she is a junior advocate. She has no income. Even your lordship is well aware how the junior, how much juniors will get. If senior is liberal, then he will pay at least 15 to 20,000. Otherwise, that will also not get. And one minor child is there. Second
no, I
son,
think his income is how much per month?
whose income? Husband's income. According to him, 85,000. He has not filed these details.
No, 85,000.
Yes, ma'am.
Now the elder son is with the father.
Yes.
What is the age of the elder son?
Elder son, 22 years.
22 years. Now he's working?
Sir. Definitely is not said, maybe like said he is. He completed his graduation,
Hmm.
whether he is working or not. Working. He is working.
Hmm. She has filed a statement of assets and liabilities.
Please, madam.
According
She
to
has
her,
filed.
what is?
He has not filed.
Not he, she.
And she is filed.
What is her income?
Her income, your lordship can see,
No, as per that, as per the statement.
as per the statement, your lordship can see, she has not stated anything. That at page 6 of her statement, she has stated that father is getting monthly income of 15,000 as a rent, and which is being credited to my account.
Hmm.
Because his father is the oldest. Because of that reason, he cannot withdraw. Then in column number F, where she has stated that monthly income is 5,000. Because she is a junior advocate and income shown as 5,000. Then expenditure, my lord,
How will a junior advocate live with 5,000? Why the seniors are giving only 5,000?
some seniors are giving, some seniors are not giving. And for that, your lordship can see here, no steps has been taken either by the bar council or by any authority.
5,000 in a present day, even to come to the court also, 5,000 is not sufficient.
Because what the seniors is telling now, they are coming for learning, not for earning.
Yes, what is?
I have a citation to rely upon.
Then in para,
Before the citation facts, no, he is earning 84,000.
Yes, ma'am.
He's earning 84,000.
85,000 from the rents only.
84,000.
Other than he is an MBA graduate.
From the rents. And he has, he need not support the first son
Yes, ma'am.
because he's not 22 years old and he's earning. The court in the earlier matter has directed him to pay an amount of rupees 10,000 towards the son's education or whatever expenses. Now, how much is ready to pay for the wife?
Not here.
Not there?
He's not here today. There's some difficulty. Because review jurisdiction, we have come before this court. That is very, virtually a factual adjudication is what is being urged by Miscellaneous Senior Counsel, which is not permitted in.
Can your colleague
Yes, my lords.
find out from
You
Pass
sold one property for rupees 1 crore and it
From
was
him some amount
deposited in
towards
his
the
account.
wife's maintenance.
Yes, Milad, 5,000 is something, Milad, which is not rational as an income, which is being shown in their assets and liability. Plus, I understand, I am
somebody-
also a junior advocate.
How
I
much you are
cannot
getting?
dispute.
Maybe your senior is paying you properly.
The male persons, your lordship may say regularly they are attending the office and female, your lordship, she has to take care of the child and she used to drop the child to the school and other things. Regularly, they are not coming to the court. That is the problem of young lady advocates.
That's, I'll just speak with my client, which can.
Pass on.
Also,
Yes, next.
Cell number 18, Antaraju NK.
tomorrow, my lord,
Tomorrow? Ask him to come. Tomorrow,
please, ma'am.
at the request of Land Council for the respondent. Yes, 19.
Cell number 18,
I am appearing for the
Antaraju.
respondent, kindly pray for time, man. Appearing for respondent, kindly pray for time, man. A week times.
Is an order in your favor?
No, Malas, against me. I sought for stay of the impugned order, Malas. Without hearing me, Malas, an ex parte order is passed. Malas, earlier, Malas, in 2016, 405 of 2006 is filed, claiming maintenance of 5,000. Malas, that was allowed. Against which, Malas, we have also filed miscellaneous divorce petition. That petition was rejected. Against which MFA 2101 of 2017 is filed, which is admitted and pending hearing. Notwithstanding, during the pendency of the petition appeal, well, she filed a petition claiming the announcement of maintenance under section 127 CRPC, which application was allowed without hearing me, without receiving the documents, without verifying the documents as to whether my income is 60,000 to 62,000 rupees or not. 50% of the salary is sought for. As against which 20,000 rupees is ordered to be paid. Against which principles of natural justice, I should be required opportunity. Order should be set aside and remanded back to the family court. I will place all the records, whether she is entitled or not, is the only question.
Then remand it. Get instructions, post this matter day after tomorrow.
Yeah.
By the time at the request of Land Council for the respondent. Yes, 20.
Number 19, Lakshmikant K.
Obligation.
Petitioner Sumangala Swami.
Please,
Yeah,
filing the objections to the judicial liability filed by the
Milad, in this
And,
case, Milad, what happened since from 2015,
And
Milad,
today-
they are deserted, Milad.
May I make?
Since
submission?
from that day onwards, Milad,
She's
only
telling
50
something, just listen to her. What is that she wants to sub?
That,
Yes.
I'm praying for some time, but today I'm not well. That's why I'm.
What is that your,
this,
the Land Council for the
objection to assets and.
respondent,
The
she is,
previous judge,
she's filing the objections to the statement of assets and liabilities filed by the petitioner. It is submitted with the council that she is not feeling well. When
we have it
No.
until.
Tuesday,
Milad, my submission is that Milad, since from.
finally will not grant.
Because
She
Milad,
is not well, that also you have to consider. Post this matter on 10th of September, no further adjournments will be granted.
Cell number 20, Syed Khalil Pasha. Petitioner Shankar.
Me, my lord. We have to file a certain liabilities, my lord, with regard to the claim of the maintenance, my lord. I wasn't, my lord,
It was not filed before the trial court.
before the trial court was not filed at all.
Lord, kindly see, my lord, for a moment, lordship, kindly, my lord, see paragraph 10 of the impugned order. It is material to note that though the respondent has appeared through his counsel and even participated during the conciliation process, agreeing to pay the interim maintenance of 15,000 per month. Lordship, now, my lord, in the impugned order, my lord, only 20,000 awarded by the,
What is his income?
lord, it is income, my lord,
Now the income, my lord, is zero. I was not earning at all.
no, my
My
lord.
health was deteriorated since 3
What
years.
is his age?
My age, my lord, is that
36, my lord.
36.
36, and
I'll produce, my lord, or otherwise, your lords, please kindly direct me to produce the
petition before your lordship, I'll produce before the honorable court. Because when the matter was posted, I voluntarily appeared before the trial court, my lord. I have admitted, my lord, that I am ready and willing to pay 15,000.
Health condition, what is his problem?
Problem, my lord, is that fatigue is there. I cannot, my lord, walk properly. That is the problem, my lord, which I am facing now. If this honorable court directed me to produce the petitioner, my lord, I'll produce. And more on top of it, my lord, during the pendency of the case, my lord, I have voluntarily admitted that
It is submitted with the land counsel for the petitioner that the petitioner is not in a position to work because of his health condition. He shall file the statement of assets and liabilities, particularly the income of the petitioner from 2023, 2024.
and also direct the respondent to also file the asset and liability because
Lord, there is no income. She is a housewife.
let her file, my lord, with
My lord,
regard to
my
the.
lord, it's-
My-
it's
My
income, my lord,
contention, my lord, is that,
the
It
proceedings.
shall also come up with the statement of assets and liabilities. Yes.
and also, my lord, she was leading life with me during the pendency of the case for a period of 3 to 4 years.
Yes, 20.
20 and 21, 22 urgent, 23. For petitioner. Introduce number 80.
Respondent in space.
Where is the petitioner?
They have filed annexure E1. Actually, they did not file the proper assets and liabilities.
Please, your
Yes.
lordship, we found that mistake. We had actually filed the assets and liabilities of the respondent here. In both the criminal MC and the MC. It was due to oversight, your lordship. Permission. will
And
be
calls
given.
for the petition submits that due to oversight, all the documents, they could not file in the statement of assets and liabilities and seeks time. Finally, poses matter on 19th September. By the time, the petition shall file all the file the assets and liabilities in the proper form. Yes.
Cell number 24. Naveen TK, party in person.
Yes. Give the note. This is a writ petition of 2013 coming up for rectification of the office objections. The when the matter came up on 19/8/2024, there was no representation. This matter was directed to be posted under the caption for dismissal. Thereafter, again on 28/8/2024, also there is no representation on behalf of the petitioner party in person. As a matter is directed to be listed today under the caption for dismissal. Today also there is no representation. It appears that the party in person is not interested to pursue the matter. Earlier, this matter was referred to the mediation. Even before the mediation center also, they could not achieve at a settlement. Considering all this, considering the fact that the party in person is not pursuing the matter from 2013, the petition is dismissed dismissed for non-prosecution.
Cell number 25. Ramesh K.
Please pass over.
Cell number 26. Hearing on interlocked application, V.V. Badrinath.
No representation on behalf of the appellant. Poses matter on October 15th.
Cell number 27. Nagaya.
The appellant in this case, my lords. But I was said that the respondent number 1 has passed away. His counsel said that the respondent number 1 has passed away, my lords. I'll take the necessary steps.
It is submitted that the counsel of the respondent has informed that the respondent is no more. He'll come up with appropriate application. Poses matter on 30th of September.
No, it's interim order may be extended.
Interim order earlier granted is extended till then.
Please, my lords.
Yes.
Serial number 28. Sarvana, yes.
My lord, I appear for respondent number 13 in this
Okay, for
matter.
respondent number 20.
Sarvana, yes for appellant.
In the appellant is not there.
Yes.
Injunction is there in the favor. Any interim order is
No
there?
interim.
No,
order.
ma'am, no interim.
No representation for the appellant.
Not just
Was
one
this matter
submission,
on
my lord.
22nd October.
My lord, this MFA itself is not maintainable for a very simple reason. I had filed in the court below. He had obtained an injunction, ex parte ad interim injunction. I filed an IA for vacating that injunction under Order 39, Rule 4. The court, after going through the objections and pleadings, everything, came to the conclusion that he had not come to the court with clean hands. He had misrepresented. He is seeking to rely on a will, which is 104 years old. He was not even born at that point of time. And he misrepresented this, whatever he was challenging in the court below was a joint development agreement, which had also been entered 15 years before. So on that grounds only, this particular order was passed in this respect of this particular IA on which he has come before your lordship. Now, he has come before your lordship on the ground that the court below has told him to pay court fees within 15 days to value the suit correctly and to pay the court fee within 15 days. In fact, my lord,
He has
that-
not questioned the injunction on.
my lord,
It's not questioned that order of where court has.
on the ground, on the other grounds, he has not taken a come up in appeal. He has only come up in appeal only on one small point. And that is that the court below apparently had told him in that order, disposing of the IA under Order 39, Rule 4, that he must pay the court fee, value the suit correctly and pay the court fee. In fact, my lord, that is not at all the ground on which it was dismissed. There was another IA that had been filed by me under Order 7, Rule 11 for maintenance. On that, the court had actually ruled that you have to pay the court fee and come, which he has taken up in writ petition in this court, which is pending, and that court has seized up the matter.
For the appellant, pose this matter tomorrow for dismissal. Yeah.
Then
Counsel for the respondent is present.
Serial number 29.
Respondent 13.
Yes.
Guruva Reddy, N.
Appellant in this case. Kindly see. The daughter has filed the suit for partition against the parents and defendant and the brothers. Now the appellant 1 and 2 are the parents of the respondent.
They're the defendants in the suit.
Yes, I'm for the defendants. Now, may I kindly see, as per the case of the plaintiff, the suit schedule properties are the joint family properties, and the father has acquired the property under the partition.
No, there is an injunction in this. Injunction is granted.
Yes, injunction has been granted
What is the injunction granted?
from alienating the suit schedule property. May I kindly see.
We'll give a short date, 18th.
No, no.
We'll pass an order for this MFAs, no interim order now. The poses matter on 18th. Petition shall take the hand summons on the counsel appearing for the respondent before the trial
ಅಲ್ಲ,
court.
ಇದ್ರಲ್ಲಿ because
Poses
he-
matter on
he's in-
19th.
he's in Tumku.
18th, by 18th, he shall file a memo to that effect. If the memo is filed, pose this matter on 19th. It will reach on that day, when the other side is there, we'll dispose it off. No two steps in this court.
Okay.
Serial number 30. Syed Akbar Pasha.
Suit for a partition, but the female family members of the Lord family had filed a suit for a partition against the father and a brother. But there are three suit schedule properties. Lord,
What is the injunction granted?
Injunction, Lord, not to alienate for a temporary period, it has been granted. Later on, Lord, in a final order, it has been.
Same order by, served by 18th, file the notice by hand summons by 18th. File a memo, 19th, the matter will be listed.
Serial number
Emergency
31.
notice, there is no.
Huh?
Notice, Lord, to take notice,
Hand summons, you have to take the hand summons to the counsel for the respondent.
please.
Taken before the trial.
Yes, in the trial court. Yes.
Serial number 31. I appear
For the petitioner, your ladyship.
Where is the petitioner?
If I may kindly
It's
request for the
online.
matter to be passed over, your ladyship.
Also, this
Obliged.
32. 32. Yes, sir, is passed over. Next matter.
Serial number 32. Hemantata Mahishi. Petitioner in this. Petitioner.
Where is the counsel for the respondent? We'll see Passover. Passover, we'll see. After.
Serial number
Any other day?
You want some other day? No representation on behalf of the respondent. Also for the applicant is petitioner is present. For this matter on 23rd of September. Yes. We should increase the list. We should increase the list. More matters of, what you do is now, with that, please ask the section to get the latest data on pendency from all. And let them get what is it as on the day we have come, as on today what it is. Entire pendency, and we'll instruct them how to list the matters from other matters also. Has to be.
ಶಾಂತ್ ಕುಮಾರ್ ಕೇಸ್ ಇದ್ರಲ್ಲ ಇದ್ರ ನೀವು ಶಾಂತ್ ಕುಮಾರ್ ಕೇಸಿ ಫೈನಲ್ ಇಯರಿಂಗ್ ಅಲ್ಲಿ ಇದ್ದೀರಾ? ಮತ್ತೆ ಬರ್ಬಾರ್ದ ಮುಂದೆ ಹೇಳಿದ್ರೆ ಏನ್ ಮಾಡಿರೋರು ಬರ್ಬಾರ್ದಂತ ನಾ ಬರ್ಬಿಡಿ. ಎಲ್ಲ ಬರ್ದ ಇದು ಮೂರು ಡೇಟಾ ಎಲ್ಲ ಇದೆ ಮೇಡಮ್ ಒಂದು ಬರ್ದಿದ್ದಾರೆ.
ಅವ್ರ ಊಟ ಮಾಡಿರ್ತಾರೆ
ಯಾವ 42 ಸರ್? ತರ್ಟಿ-2 ಆರ್ಡರ್ ಆಗೋಯ್ತು. ಅದೇ ಅವ್ರು ಟೈಮ್ ಒಂದ್ ನಿಮಿಷ ಸರ್.
ಆರ್ಡರ್ ಹಂಗೆ ಕಂಟಿನ್ಯೂ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿದೆ ಅಲ್ವಾ? ಇಂಟ್ರಿಮ್ ಹೌದು. ಇಲ್ಲ, ನಾವು ರೆಸ್ಪಾಂಡೆಂಟ್ ಹಸ್ಬೆಂಡ್, ಅವರು ಪಿಟಿಷನರ್. ಎಂಟ್ರಿ ಮಾಡ್ರಿದೆ
ಏನು ಕೇಳಿಲ್ಲ, ನೀವು ಕೇಳ್ಕೊಳ್ಳೋದಾದ್ರೆ ಕೇಳ್ಕೊಳ್ಳಿ.
ಅದೇನು ಟಿಲ್ ದ ಡೇಟ್ ಅನ್ನಿತ್ತ
ನೋಡಿ,
ಇಲ್ಲಿವರೆಗೂ ಅಷ್ಟೇ ಐತ ಡೇಟ್.
Withdrawal one.
I don't know. Nayak Nityanand Venkatramana.
Appellant. I am the plaintiff in the original suit. Suit is for specific performance. The court declined to grant the ex parte injunction order. Instead of preparing the MFA, I prepared the writ petition. Writ petition was entertained and considered interim protection was granted. The writ petition was pending for about 2 years. And at the time of final disposal, the writ petition came to be dismissed as not maintainable, my lord. And direction was issued.
This has come up earlier before
Please,
this
ma'am.
court. No, you wanted to withdraw this.
Please, ma'am. Direction was issued to the trial court
No, I know,
to
nothing is required.
expedite
If
the,
you want to withdraw,
I am, my lord.
give that.
Now I am filing the memo. Permission to withdraw the MFA with liberty to challenge the subsequent orders. my lord. Because liberty was not reserved in the writ petition to prepare the appeal, MFA. That was the observations made by the honorable court. ma'am.
You have questioned an order passed by the trial court by filing a writ petition.
Please.
In the writ petition, there is an observation that writ is not maintainable. And apart from that, as far as that order is concerned, some mention is about that. You have not sought for any.
Liberty
court
was not
liberty.
reserved to prepare the appeal.
Liberty this court should give you.
No, in the writ petition, liberty was not reserved, my lord.
What is not given in the writ petition? Why will this court give you now?
No, I am seeking the permission to withdraw the MFA,
Yes.
reserving liberty to challenge the subsequent orders, my lord.
For that, a liberty is not required. That's what I'm saying.
Please, ma'am.
For any
Okay.
subsequent, no, unnecessarily, let's not complicate the matters.
Please.
Now,
Otherwise,
you questioned an order passed by the trial court and you want to withdraw. Now, how will it come in your way?
in terms of the memo may kindly be taken on the record and
No.
permission may kindly be granted to withdraw it.
Court has to understand what is the liberty.
I am only,
There can't be liberty like whatever.
No.
No, that can't be.
I have challenged the order in declining to entertain the ex parte injunction, my lord.
No, for example, the court will not grant you liberty. For example, the court is not granting you liberty. How is it? How are you affected by that?
Please.
Anyhow, you cannot question the very same order because
I am
you've
not
already
challenging the very
withdrawn.
same order. Please, ma'am.
Yes.
That with me.
The memo is filed seeking to withdraw the appeal. With the liberty to challenge the subsequent orders passed in the original suit in the interest of justice and equity. The petitioner can withdraw the writ petition, but the liberty that is sought cannot be granted by this court. And it is if any subsequent orders are passed. For that, a liberty is not necessary from this
Yes.
court. Facilitating the petitioner to question them in that view of the matter. The memo is taken on record as far as the withdrawal is concerned, but no liberty accordingly dismissed as withdrawn. Yes.
Much.
My lords, I appear for in serial number 15, my lords. I'm
Number-
seeking for an adjournment of 2 weeks, my lords.
At 2:30, serial number 1. Number 2, serial number 1. N. Suresh.
Yes. Is appearing online or somewhere in here? N. Suresha.
N. Suresh.
This is an appeal of 2023. Officers raised as many as 11 objections. Even before the registrar also. This matter was listed on 25/9/2023 and 25/10/2023. And 10/11/2023. 10/11/2023, 19/3/2024. When the appellant had failed to comply with the office objection, the matter is posted before this court. This matter came up on 2/9/2024, as there is no representation on behalf of the appellant. The matter is directed to be listed today under the caption for dismissal. Today also there is no representation. And the petitioner filing an appeal until now, after, even after lapse of several months, has not complied with the office objections. It appears that the applicant is not interested to pursue the matter. Accordingly, dismissed for dismissed.
Non-compliance third time, serial number 2, Geeta Devi MP for appellant.
The appellant, my lords, give us a date that we will apply the.
When was the time granted to you? No, this can't go on like this. Everything, then we will impose costs and grant you a week's time. Thereafter, we'll dismiss.
Give us a short.
No, when was the earlier order? What was it says for the third,
It's on 18/6, my lords.
in spite of lapse of more than 9 months, the counsel for the appellant has not complied with the objections raised with office. Hereby directed. Finally, a week's time is granted for complying the office objections, same default order. Yes, 9.
Serial number
Next.
3, Prashant BR.
No representation for dismissal tomorrow.
Serial number 4,
Same, 4, 5,
4, 5,
6, 7.
7. Serial number 8, up to 12,
Yes,
tomorrow for dismissal.
for dismissal.
Yes. Serial number 13, fourth time,
Weeks time.
Jagdish KJ.
10.
10 Prashant BR. List number 2,
Give the plan.
serial number 13.
Yes, 13. Finally, a week's time is granted. Same default order. Next, 14.
Serial number 14, Venkatesh.
Yes, week's time default order.
Serial number 15,
My lords, I appear for the
Gautam
petitioner,
S.
my lords.
Bharadwaj.
I'm seeking for a week's time, my lords.
Yes,
Serial number
16.
16,
Obliged.
serial number 16,
No representation for dismissal tomorrow. Passports.
passed over matters. Serial number 10. Serial number 10, Manjunath.
For the
Mishra.
appellant, please. Case number 31 is the impugned order, ma'am.
What is the suit for?
Suit for partition filed by the respondent number 1 herein. The appellants herein were the defendant number 3 and 4 and 5 before the trial court. The case of the plaintiff is that she has sought for a partition in respect of 2 items of the property.
You're the family member or a
I
third
am the
party?
purchaser of the item number 1, Schedule A property, please.
From whom?
From defendant 1 to 3, please.
Defendant number
1 to 3.
1 to 3. When did you purchase the property?
In the year 1995, please.
1995.
Please, ma'am.
Suit is of which year?
Suit is of the year 2014.
2014.
And
Please
defendant
come.
number 3 has admitted the fact that they have sold the property upon receipt of consideration from the D4 and 5. As per the para 5
So
of the
what is the injunction granted?
injunction, my lord, in the meantime, my lord, the D4 and 5 have entered into compromise with the plaintiff. They have paid certain amount and settled the issue with the plaintiff. And accordingly, compromise petition has been filed. And along with that, the plaintiff has also filed an application under Order 1, Rule 10 to delete respondent number 4 and 5. And since defendant 1 to 3 have taken a contention that it is not available for partition, it has already been sold. And plaintiff, since it has been compromised, plaintiff has filed an application for deletion of R4 and R5 and also item Schedule A property, for which defendant 1 to 3 has raised objection. And there are other items of the property that is pending. Item Schedule B property is pending. And the learned trial judge was pleased to pass orders on all the 3: compromise petition, deletion application, and in the meantime, defendant 1 to 3 has filed another application under 39 Rule 1 and 2, seeking a direction for restraining the D4 and 5 from alienating the property.
Defendant files an application.
For restraining the defendant 4 and 5 from alienating the property.
The people who have sold the property.
Who have sold the
after-
property.
That is granted.
Please, madam, that has been granted.
Come
Yeah.
to that order.
Page number 26 is the common order has been passed. And here, my lord, the learned trial judge has misdirected that defendant 1, 2, 3 has sought for a counterclaim in respect of some other property. One property standing the name of plaintiff. And learned trial judge has
They themselves have stated that they have sold the property
Please,
in
my
your
lord.
favor.
Para number 5 of the written statement, my lord.
Then please come to the relevant finding.
Finding, page number 30, para 6, my lord. Defendant 1,
What is this compromise? Compromise is between the plaintiff and you.
D4 and 5, please, my lord.
That is one. IA number 2 of 23 filed by defendant number 1 to 3 under so and so
Please,
is allowed.
allowed.
4 and 5, then meant so and so. Please come to the relevant.
My lord, page number 30, page para
Yes,
6.
read point number 6.
My lord, defendant 1, 2, 3 filed this application for restraining defendant number 4 and 5A from alienating the social properties. Defendant number 1, 2, 3 stated that if defendant 4 and 5A alienates the suit property, the purpose of filing the suit and their claim made in the suit scheduled properties will be deprived of. The defendants 4 and 5A also submitted that they have purchased the suit properties from defendant number 1, who is the absolute one of the social property, and they cannot be restrained by any order of this injunction. This suit is filed by the plaintiff against the defendants for relief of
What
partition.
is finding of the court? Court says that for the purpose of, as if like the plaintiff had sought for injunction, the
Please,
court
my
had
lord.
passed an order.
That is a wrongful interpretation.
Then come to that compromise.
Compromise.
That order, where is it?
A common order, madam.
No. Where is it recorded about the compromise?
At the point number 1 at page number 27. The suit is filed by the plaintiff
No,
against.
before we go to this, please come to the written statement and where is the admission?
Please. Page number 47, para 5. Please. Written statement of defendant 1, 2, 3. Para 5, the
To the
defendant.
fourth and fifth defendant, and the two registered sale dated so and so. Please come.
Please.
Is an injunction not to alienate.
Please.
The appellant, who is defendant number
4 and 5.
defendant number 4 and 5 before the trial court, is agreed with the order granted by the trial court, restraining them from alienating the property. The defendant numbers 1 to 3 are the vendors,
Please, vendors.
are the vendors of defendants 4 to 5. They filed a written statement stating that they have sold the property in favor of defendant number 4 and 5. During the pendency of the suit, there was a compromise between the plaintiff and the defendant.
4 and 5.
And the defendants, the plaintiff want to forego the
Please.
relief against defendants number 4
Four
and 5. And he also filed an application to delete them as party respondents to the suit, as defendants to the suit. In that, the defendants have filed an IA whereby they have sought an injunction, defendant 1 to 3, who are the vendors of 4 and 5, restraining them from alienating the property. The trial court, by order impugned, had allowed the said application, wherein the court observes that the suit is filed by plaintiff against defendants for relief of partition and separate portion of the suit scheduled properties. Defendant number 1 to 3 claim their counterclaim of the suit properties will be deprived of if the defendants 4 and 5 alienates the suit scheduled properties during the pendency of the suit. Therefore, in order to protect the property in disputes, it is necessary to issue temporary injunction as prayed for and accordingly restrain the defendants from 4 and 5 from alienating the property. The trial court, when the defendants 1 to 3 themselves have filed a written statement stating that they have sold the property in favor of 4 and 5. Or 4 and 5, that as particular aspect was not discussed with the trial court and granted the injunction in that view of the matter. Where is your interpreter?
That I filed two separate IS.
Where is that?
My lord, page number. Page number 94, please.
What is the other IA?
Other IA to stay the further proceedings, one IA, please, my lord, and another IA to stay the.
Accordingly. The impugned order dated, they shall be stay of all further proceeding. Pursuant to the order dated 15/2/2022, passed on A number 2 of 23. Filed by the respondent 2 to 4.
Right.
The next para, learn counsel for the petitioner, applicable on, learn counsel for the applicant shall take notice of the counsel appearing to the respondent before the trial court and shall file a memo to that effect by 18th of September. And list this matter on 23rd September. If the memo is not filed, the interim order granted by this court stands vacated without further reference to the court. Interim order is still the next date of hearing.
Lord, I sought for a stay of that impugned order.
Stay is granted.
No, further operation is stay of that particular order.
The order is the next IA also. Yes. No, why no, one is sufficient, but one is suspended, then the suspension, that the second IA that he filed, no, that this is not required. Yes.
Sale number 25. Ramesh A.
Yes. Await service of notice.
Notice I'll send.
When is it, sir?
Wait until already.
Huh?
Already 29/6 or 7.
Notice is served.
Served or not, await.
It appears that await service of
Yes.
notice.
Yes.
Await service of notice. Then why did you ask for time in the morning? When it is, the notice has to be served on the respondent.
Yes.
Await service of notice, post after service. Yes, next.
Sale number 31. Sale number 31.
Senior's on his way. If I may kindly request for a passover, he'll be here in.
How is it possible? How can you ask? What is on the way when the matter is listed before the court? You ask for a passover in the morning. Any urgency for you?
No, my lord, not.
Oppose this matter
If it may be taken up.
on
day
October
after.
14th.
Your lady, execution proceedings are listed on
Then
24th
you
of
have to be
September.
there when the matter is called, or you have to argue. How many times the court will accommodate you?
One chance maybe.
Oppose this matter
Absolutely no.
tomorrow.
Tomorrow.
Much obliged.
Tomorrow I will not even grant passover.
Certainly. Much obliged.
For 230 orders, sale number 33. Hanumantarayappa K.
Yes, my lord, 1 week's time. my lord.
Huh?
1 week time, actually, we have to furnish certain documents, my lord. It is not for, still furnished.
If
by-
you people are not interested to argue the matters, court can't help it.
Kindly 1 week time, my lord.
Office objections are complied with?
No, that that is for office objections only. There is
Why, how many times you want?
some
how many
documents to
times?
be furnished, my lord. We have. informed the
2011,
client.
2023, none appears. Then an order is passed dismissing the appeal, recall of the order. Then the order is recalled. Then on 4/6/2024, 2 weeks time is granted for compliance of office objections. You do not comply it. Again, you ask for time. Finally, a week's time is granted on payment of cost of rupees 2,000 to the Advocates Association. Same default order. Yes, 34.
Sale number 34. Muni Krishnan M.
View the file.
Appear for referendum, my lord. Kindly granted 1 week's time, madam.
Hmm?
Kindly granted 1 week's time, madam. We paid cost of rupees 2,000 on 31st August.
You paid the cost?
Yes, madam.
Then what about the office objections?
We comply.
Complied.
No, madam.
Why are you not complying? Earlier, that costs are imposed because you have not complied. Now you pay the costs and you will not comply with the office.
And it under 2 days time, finally 2 days.
It is submitted that as per the orders passed by this court. Where is the memo
We filed it 31st August. In
that,
count.
costs as directed by this court are paid and finally seeks 2 days time by Thursday, if the office objections are not complied with, the appeal shall stand dismissed without further reference to the court. Yes,
Till number 35.
I am for the appellant, my lords.
Yes.
As per the memo dated 15/2/2024, the appeal may be withdrawn as not pressed, my lords. I filed a memo.
memo for withdrawal.
Fifteen to 2024.
22/6/2024. Yes. This is 5/7. 22/6. It's not there, Mr. Counsel.
Yes.
For it will pass in order. Yes, 36.
Till number 36.
Appealing for the respondent 7.
I'm appealing for the appellant.
Mohit, sir.
My lord.
Please to R1 and R3 to R6.
R6 PF is paid.
When did you pay?
Today for the
That
third time.
counsel submits
One
that the
submission.
office objections are complied with.
Memo has been filed on 22/6/2024. The interim order of maintain status quo has been granted. During the maintain status quo, they are making a construction. I have filed a memo dated 22/6/2024.
Which respondent is making construction?
Respondent number 6.
But for respondent number 6, notice is not served.
They are on record.
7.
7, sorry.
You have to wait. The land counsel for the petitioner submits.
Respondent 7.
He has already 1 minute. He has paid the process for issuance of notice to R1 and R3 to R6. Pose this matter after service of notice.
I have to file certain additional documents, my
What
lord.
you do? I mean, nothing is going to be done. Yes,
One submission.
yes.
Further, they are making construction. That also I am filing a memo. That may be also taken.
File it in the section. Now we can't, they're not served. Already there is an order of status quo.
State.
Let them come. Yes.
Stay may be, maintain status quo may be.
Interim order
Granted.
granted is extended till the next date of hearing.
Much.
Till number 37, Karnataka.
Propellants, already needful done.
Needful is done. Then council submits that. The needful is done. Post after service of notice. Yes.
Short date next
Till
week,
Huh?
next date, short date. Next week.
Whenever the notice is served, it will come. That's what.
Till number 38. K. Vani.
Petition has already been complied.
No maintainability of the appeal.
Maintainability, it was also changed, 28 Bharat.
Huh?
28 of Hindu Marriage Act.
No, what is the impugned order?
Impugned order is against the divorce has been granted, but alimony, life alimony has been awarded about 7.5 lakhs. He being a coolie, appellant is a coolie, it was admitted by his wife, that is a respondent.
No, how can that be questioned here? If alimony is granted in a divorce proceedings,
Yes,
that's a part of an order which has to be questioned before a division
they are
bench.
challenging about the alimony only.
Still you have to question it before the division because a final order on where a decree of divorce and also alimony is granted, question it there. How can you file a writ petition against that? RPFC against that?
RPFC.
No, RPFC doesn't lie. It's a final order.
That is the final order.
Decree, there is a decree of divorce and that alimony is granted. How can that, how can you split those two?
Yes.
Ultimately, that's a decree
Yes.
where divorce is granted and alimony is also
Alimony is
granted. If
also
you are
granted.
aggrieved to that limited extent, file an appeal. The office has raised an objection with regard to the maintainability of the appeal in view of section 19(1) of the Family Courts Act.
And my lord, one thing, can it be transferred to the?
You have to do it.
Yes.
You have to do it. You have to take out, make the necessary corrections. It's a division bench. Appeal will go to the division bench. What did you write? In view of section 19(1) of the Family Courts Act. This MC, the order impugned before this court is a judgment and decree whereby whereby the petition filed under section 13(1) of the Hindu Marriage Act for divorce on the ground of adultery and cruelty is decreed. And the marriage between the parties dated 17/12/2014 is resolved by way of a decree of divorce, which shall come into force only after expiry of 90 days from the date of the decree. And the court had awarded maintenance of an amount of rupees 7,50,000 and also cost of 20,000 from the respondent. Against that order, the husband has filed this RPFC. And counsel submits that they are questioning only the alimony, but not the decree of divorce. As such, they have filed an RPFC. And the office has taken the objection with regard to the maintainability. The office objections are sustained and in view of section 19(1) of the Act of the Family Courts Act, against this order, an appeal lies to the an MFA lies to this court. The petition is permitted to withdraw this petition and convert the same into a MFA. Yes. Within 15 days from the date of receipt of the copy of the order. Yes. Next. Dismissed as withdrawn with the liberty to file an appeal. Yes.
Till number 39.
Registry shall give back return all the records.
39.
39, my lord, and for the petitioner, there is no response from the petitioner to find out the address or to file application for substitute service. So hence it may be dismissed for non-prosecution.
You are here.
Yes.
Either you have to give your there should be a retirement memo or something.
Even a retirement also there is no. I think this is a family matter. He has challenged
The
maintains.
the petition submits that in spite of his best efforts, could not contact the client. His whereabouts are not known. Hence, and this is a petition of 2021, which is coming up before this court for non-filing of appropriate application for substitute of service to the respondents. Considering the submission, it appears that the petitioner is not interested to pursue the matter. Accordingly, dismissed for non-prosecution.
Till number
40.
40. Till number 40. Govind.
Petitioner, mother petitioner filed GNWC before the family court by virtue of order passed on IA number 5. It was
This is IA number 2 of 23 by respondent. Who is the respondent?
before this court, before this father respondent.
Nanda Kishore. Where is he? Shall we have it tomorrow?
Yes, my lord. Yeah, but they have not been regularly coming, my lord.
Tomorrow
Despite,
we'll,
yeah, yes,
we'll record it today.
yes, ma'am.
Tomorrow we'll pass, then we'll pass on.
yes, ma'am.
The land counsel for the petitioner is present, no representation on behalf of the respondent. Post this matter tomorrow.
2:30.
Huh?
2:30.
No special categories.
Much,
Yes.
much up.
Till number 41. Vinod Prasad. Okay, just G.
I'm for the respondent, Mela. May I file the objection for me? Yeah.
Non-filing of memo having served hand summons to counsel for,
All
you're
three-
appearing anyhow.
Yeah.
Yes. Have you served on him?
Yes, I have served.
Just now I have received. I look into it.
The petition, file it in the section. Why are you filing
Please,
here?
please.
The particular counsel for the respondent submits that he is filing his statement of objection today. Land counsel for the petition submits that he has received the same that is served on him today. Pose this matter on September 23rd.
Yes, Mela. Well, for misrepresentation, it's about 30 lakh rupees paid to the respondent. So they have not paid single paisa.
I look into it and make
Let's
my
see on that.
submission.
Yes.
Yes.
My interim order kindly be extended.
Why? What is this one? MFA number 4614 of 2020. Yes,
Interim order kindly be extended.
interim order earlier matter extended to the next date of. The memo is filed stating that the appeal is filed challenging the judgment dated 15/4/2023 passed by the District Court Mangalore in AP number 138 of 2022. It is stated that in view of the approval of the competent authority for implementation of the arbitral award to withdraw this writ petition, the memo is taken on record and they want to withdraw the MFA. Memo is taken on record and appeal is dismissed as withdrawn. Yes.
Cell number 42 for final hearing. Cell number.
Tomorrow, my lord, the senior is end appeal for
2014 appeal
tomorrow I will.
tomorrow at the request of learn.
9th, my lord.
Huh?
Tomorrow and day after tomorrow. we are in-
Ninth is difficult. Monday,
We are in Dharwad, my lord. That's why.
then we'll have it on 11th,
My lord, 10th, my lord.
post on 10th.
Much obliged.
At the request of learn calls for the applicant, no further adjournments will be granted.
Please.
Done. Ask them to come, you also come along with the data. Let there be a more list from tomorrow. Yes. Nothing for the signature? It's okay, doesn't matter.
Even for the land, up there. Even for the moon, 40. 4614 for disposal.
41 leading ಎಲ್ಲ separate ಆಗಿ பண்ணனா
ಅದೇ. Cell number 40 ಕೊಡಿ. 4614 ಅಲ್ಲ? 4614 disposal. That's it. 40 ಅಲ್ಲ? 40 ತಗೊಳ್ಳ.
ಎಲ್ಲ separate ಆಗಿ ಕಳಿಸ್ತೀನಿ ಆಯ್ತಾ? ಬಾಕಿ ಇದೆಲ್ಲ
ಸೆಪರೇಟ್ ಆಗಿ ಇದೆ ಅದು.
ಅದು ಸೀರಿಯಲ್ ಆಗಿ ಇದೆ. ಏನಿದ್ರೆ ಮತ್ತೆ
ನೋಡಿ ಇವತ್ತು ಬೇಗ ಮುಗ್ದೋಯ್ತು ಅದಕ್ಕೆ ಮೇಡಮ್ ಸಮ್ ಮೋರ್ ಮ್ಯಾಟರ್ಸ್
everybody will